You guys can see the folder that I have up. I'm going to open up a document here. I'm going to open up this Declaration of Trust. Does everybody see this? And then I'll just go and we'll just jump right in and we'll get a good hour worth of really core content. Let me just hit here. And questions. Yes, 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 yes. All right, great. Without further hesitation, let's jump right in. The first step, and I'm just gonna pre-frame and say this process that I learned is the result of years of study and research from mentors and individuals that shared the material. And the individuals that use this process, now there's many different theories out there. You've got a lot of theory that's floating around out there, people that come up with new ideas, you know, Boris and the Usufruct, David Clarence and the Executor, you know, all these people popping up, coming up with their new theory that's been around for 1 or 2 or 3 years. This process has been around for about a decade. It's been adjusted, it's been amended. We like, in the status correction course, we go over week by week, you know, everything having to do with status, okay? Including getting an international driver's permit where you do not need a driver's license and you just show it's an internationally recognized driver's, quote, permit. It's not a contract. It's not an adhesion contract with the United States or a franchise, a subsidiary like the state of California, the state of New York, etc. But we've gotten them. We have them. Passports of non-14th Amendment citizenship issued from the Department of State. And this is not you printing your own passport. This is not you printing your own license plates from your computer. This is from the Department of State issuing you a passport saying you're an American national, not a U.S. citizen, property, 14th Amendment slave. Okay, so we're able to get things like that. We can, on the status correction class, we will show you those redacted paper with the people's, you know, names and private information, you know, blanked out. We're putting those together. Okay, so this stuff works as far as getting recognized identification that you are a private living man or woman, or you're a private non-corporate employee of the federal corporation, be that Australia, UK, America, you know, wherever you're talking about. People have won court cases of every kind. People have gotten paid 6- and 7-figure million-dollar common law tort claim processes after getting their status corrected, specifically using this process. So that's why this process, or this plethora of processes, has been selected to be kind of the focus point of this webinar and the status correction course. Okay, so it's not theory. It's based on results. You know, when you've seen people that have been, you know, imprisoned for, you know, 2 days or 10 days or 10 years sue the United States government for wrongful imprisonment and actually win millions of dollars, and when you actually seen the United States Treasury checks that have been sent in a payout as a settlement to settle the common law claim against the prosecutors, against the United States of America as a corporation, etc. When you've actually seen that stuff, your level of knowledge and belief that this is the right process, you know, goes through the roof. Okay, and when you deal with contractors who regularly do that every season, you know, maybe every month, and actually get people paid money or dismiss their criminal charges, or other remedies like that, when you actually see that regularly, it brings a whole nother level. So that's where I'm talking to you from a point of understanding and experience. You know, you want more information, you want to see more proof, you want to see more, you know, success cases and things like that. We welcome you to join our status correction course, or to call the number on the website, the 505-340-3632 number at any time, and you can chat it up with Jay. He'll give you a free consultation if you call and you say, you know, I just have some questions and so on and so forth. Just call us. We're available. We're a phone call away. We're an email away. Start a conversation with us, and you know, whatever you need to hear, whatever you need to see, maybe we can provide it, maybe we can't. But we're just going to be sincere and honest about what we can do, what we're still working on. Okay, but this is the forefront of where a status correction, a secured party credit remedy process would start. The bottom line is, and we've got an article on the website. If you scroll down to the second to the third, again, this is all the stuff that's covered in the status correction course, itemized here in this post here. You've got this, right here. So we're going to go over some of the initial material, but this is the entire list. So anything that's not on here may not be covered. So just ask if you are specifically looking to learn something specific. This is another overview video we did. It's an hour and 50 minutes explaining the whole status correction process. It's a big overview. We're only going to go over one of the steps, which is setting up the initial trust, which is the precursor to the UCC recording process. If you scroll down, here you go. Did you know that your legal name, John Henry Doe, is a constructive trust? Okay, you must read this if you want to understand the documents that I'm going to show you. Okay, the legal name, John Henry Doe, or whatever your capital letters name says on your birth certificate, on your driver's license, it's a trust. Okay. If you don't understand what a trust is, you got to go and research what a trust is. We have lots of videos on our YouTube channel, youtube.com/wincontractlaw. We have a video called Public Trust, Private Trust Explained. Watch that video. You've got Weiss's Concise Trustee Handbook. You've got a lot of free material out there about trust. A trust is basically a grantor or the creator of the trust, also known as the settlor, via creating a contract with the trustee. Now, how do you form a contract? It has to be an exchange of something of value as well. Okay, just like in a marriage, you exchange wedding vows and wedding rings, and that solidifies and cements the contract. Okay, it's a little bit more powerful, or it's a lot more powerful than just signing a piece of paper saying I promise to do whatever. You have to give something of value. That ring is what is the property or the res, okay, in a trust that actually grants the state control over your marriage, control over your financial affairs, your tax affairs. It's basically a corporate merger between the two trusts. So John Henry Doe and Jane Henry Doe get married, and they form, if they get married by the state, they are giving the state a interest in the products, the tax implications and liability, in a sense, the finances are conjoined together. Any disputes must be adjudicated by that state. Okay, so that's the divorce proceedings. You would be subject to the opinions and rulings of a judge, which may be slanted and tipped for or against your favor. So do you want to contract and get some judge to be able to determine what would happen, how would the assets get split if you split? And also the offspring of your marriage is now property of the state. So that's what happens when you get, married. But the legal name, the John Henry Doe legal name, is a constructive trust. Why is it a constructive trust? Because there's two kinds of trust, constructive and express. Okay? So an express trust is this. This is a private express trust organization. Okay? As you can see, I will just start reading. This contract and declaration between the undersigned parties, known hereafter as the creator or grantor and the exchanger, agree to wit. Creator herein offers for consideration to create an organization under the common law having a fixed number of certificates which evidence a right of distribution commonly known as a pure trust organization or unincorporated business organization. And exchanger herein agrees to exchange in trade goods and valuable consideration for certificates of the newly created organization. Therefore, the parties mutually agree, promise, and covenant as follows. Consideration. Exchanger herein agrees to bargain, exchange, assign, convey, and deliver to this organization or its appointed trustee. Immediately upon the execution of this agreement, Creator agrees to appoint a trustee having authority to carry out the exchange and hold and administer the consideration received. The initial exchange, a description of the consideration, whether personal and or real property, and the number of certificates issued shall be documented in the minutes of the organization. How many of you who have trusts are actually documenting minutes of the trusts? How many of you are actually documenting bills of sale and issuing certificates to the exchangers or beneficiaries of the trust? And in our experience, not many people. Many people are just putting together this declaration of trust. Now, why am I going through this? Okay, you got the administration of trust estate, irrevocable agreement, appointing of the trustee, board of trustees, discretionary power, acceptance by the trustees, administrative provisions, yada, 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 all the way on 7 pages, and in witness, the term of years, the legal domicile, the common law, the purpose and intent of the agreement, signature between the parties, and witnesses, okay? So this is an express trust. A trust is a contract. It's a specific kind of contract in which there is one person's putting property into the hands of another for the benefit of yet another third party or parties. Those third parties are called the beneficiaries. Okay, so look at this graph here. Go online, find a little triangle between the 3 parties of the trust, grantor, trustee, beneficiary. But the bottom line is it's based on contract. It's based upon a meeting of the minds. It's based upon consent. The John Henry Doe legal name that was created with your birth certificate being stamped with, or your registration of live birth with your foot being placed on that, and the description or the metes and bounds of the description of the property, which is you, which is the res that was put into the trust, that is just like the marriage, where now you're contracting the state to be in control of this trust. Okay, so if that makes sense, I just want to see if you guys say yes or no, or if you have questions. Please, we're going to do questions only about what I ask about, because I'm trying to sequence this and have the most amount of people understand, you know, the main point of the webinar. If you have other questions, send us an email, set up a coaching call. You know, there's many other forums to ask off-topic questions, or maybe at the end of the presentation, I can spend another hour with you guys and ask, you know, non-direct questions. But let's see if you have any questions about what I'm talking about. Do you guys understand that the John Henry Doe Trust, your name, your legal name, is a trust? It's not you. It's not a corporation. It's a trust. The kind of trust, it can either be express or constructive. Express is like this, where all the meeting of the minds is documented on paper and expressed, signed and witnessed by the parties. That's an express trust. A constructive trust is, well, they just took the property or the res, they gave it from one party to another, and there's no clear, you know, it's not clearly spelling out for you that it is a trust. But you have to, like, use your common sense to determine that it's a trust. You have to figure out that it's a trust. Okay, so do you guys understand that, or is that over some of your heads? Let's see, 87 questions. I understand the trust. Okay, yes, I got it. When the child is born and trust. And by the way, you guys can raise your hand and I can unmute you, but it's going to have to be quick because we're trying to just get through a lot of material here. At the end, we can chit-chat. I'll stay up as late as you guys want. Access in the trust. What does that mean? State is the trustee. Got it, got it. Is that like a domestic trust, as it says in the IRS website? Sounds like you'll have to go soon. Da, da, da. Why don't you believe A for V? Why do you pay federal income tax? Okay, these are questions for the end. We're just going to go on topic. Those are from a little while ago, but okay, yes, understand. Does anybody want to raise your question? Because I don't want to leave people behind. And when you get this, you'll understand how powerful that this is. And we can go through all the 15 documents, you know, a little bit quicker. But, you know, foundation is always what you need to spend the most amount of time on. So, can the trustee give a birth certificate to put in trust? A certificate is something that's issued because the legal title is being held elsewhere. Okay, so you can't put a certificate. If you put a certificate into a trust, it doesn't mean that the trust has a legal title. It just means that the trust has equitable title. Does anyone have a question about what I just said? What if I have authenticated the birth certificate? It doesn't change the fact that the legal title is still not held by you. Can I explain it some more? Okay, what do you want me to explain it some more? It's second nature to me, so I don't know. You guys got to really like, for the asking of the right questions is for the giving of the right answer, as we say. You're not the holder in due course. You just have a certificate, okay? The legal title is still in control of the government. They have something else. They have that registration, okay? So you haven't collapsed the trust but just by getting an authenticated copy of your birth certificate. All you're doing is authenticating that that's an original, true, and correct birth certificate. So what? It's just a certificate. It's just like having an authenticated apostilled certificate of title for your car. It doesn't mean that you can take the tags off and the license plates off. You're still going to get pulled over and harassed by cops. Does that make sense? Yeah, split title. You got to look up split title. A trust splits the title. When the, let me try to zoom in a little bit to this. Okay, so when the grantor gives a exchange to the trustee maintains legal title, and the beneficiaries are issued a certificate, and the certificate holders have equitable title. Okay, and that's why you can use your car, you can sell it to someone else and sell the certificate and the ownership and interest to someone else, or a corporation or another person, any legal entity, an individual or a corporation or a trust. You can sell it to someone else. You could paint it whatever color you want. You could, get whatever boombox, system. You can get whatever type of rims you want on it. If you want to flare out your car, if you're one of those guys that do that, and really into your car and doing all that stuff, you could do whatever you want to your car. You could clean it, you could vacuum it, you could throw McDonald's wrappers on the floor, you could do whatever you want. Okay, you can have anyone that you want as a guest driving shoddy in the car, or driving in the back, or sitting there as a guest in the back of the car. You can do whatever you want with it. Okay, that's equitable title. Okay, but you don't have legal title. Legal title is control. They set the rules and regulations, and they can fine you and seize the property if you violate their rules and regulations. Okay, so how is that any different if you have a certificate of live birth that's authenticated and apostilled? All that's saying is this is a true, authentic certificate. I have equitable title. Okay, doesn't mean you have legal title. Okay, the process we're going to go over is a process that helps you to take control and maintain legal title. Okay, but in order to maintain legal title, you need to give equitable title to someone else, because you can't have legal title and equitable title and have it still be a trust. Okay, you need to select, in this process, you need to select other beneficiaries and give them certificates of interest that makes them the owners of John Henry Doe. That makes them the owners of the trust, John Henry Doe. And when you do that, and you got your proof of mailing and they've accepted it, if they signed a document and sent it back to you, we just put on the website. We just gave you that document right here on our website, posted January 26th, notice to beneficiaries of a trust. This is what you would send to your beneficiaries, have them sign the bottom letter, but they don't have to sign the bottom letter. I'm going to read this to you. It says, let me just pull this up a little closer here. All right, notice to beneficiaries of John Henry Doe Trust. Dear Bob Joseph Doe, this notice is to inform you that John Henry Doe, the living man, see how it's punctuated with the colons and the hyphen and the colon, that means John Henry of the family Doe, the living man or woman, flesh and blood, has executed an irrevocable express trust on so-and-so date, to be handwritten in there, naming you as a beneficiary. The trustees of the trust are, first trustee, John Henry Doe, information, second trustee, Mark Dennis Awesome. Mark Dennis of the family Awesome. He's awesome because he's the second trustee. As you will learn as we go through this, the second trustee is the most important part, or the most important individual that you need to enroll to be a part of your trust. Okay, you need to have two trustees. Otherwise, you being the only trustee, there's a term called in persona conjuncta. I'm going to type it in here again. In persona conjuncta. Look it up. It means that you are the trust. You don't want to be the trust. You just want to be a trustee of the trust that has a hold harmless agreement that you'll have no liability operating as trustee of the trust. And you've got that recorded on public record with your UCC1 recording, and we'll get into that a little bit later. And you have a security agreement that covers a lot of bases to reduce your liability and set the terms and conditions and so on and so forth, okay? And yes, it places a lien on the property assets of the trust, first in time, first in line, so on and so forth. Yes, Yolanda says, I compare to being stockholders. The beneficiaries are compared like in a corporation. They would be like the stockholders, only this is a trust, so we call them the beneficiaries, not the shareholders. And they're getting certificates of interest, just like how in a corporation you would, here's a sample, okay, and we're in the process of creating a variety of different kinds of fancy colored borders. You can have it vertical, you can have it be, you know, lengthwise, horizontal. You know, there's no you know, a lot of membership certificates and interest certificates for corporations or LLCs or whatever. You know, a lot of them are actually like, you know, a little bit, you know, in other words, you can design it any way that you want. It doesn't have to be this document. It doesn't need to be a blue border around it. And we're going to design a few pretty templates. We have some good graphic, you know, designers that we solicit to, you know, help make this a little fun, give people a little bit of options and personalization to their processes. Okay, so but this language and stuff is right at, like a lot of it is right out of Weiss's Trustee Handbook. A lot of it is right out of The Art of Passing the Buck. The language in here has stood the test of time. You can switch, you know, the numbers around a little bit. You can, if words have the same meaning, you can switch it around if you're really comfortable with it. But if you're pretty new to this, I wouldn't switch the language around. So, you know, we have where you can get the language here. And we did post something on YouTube about certificates of interest as well that you can check out there as well. On the, I'll type the link into the chat bar in case you guys trying to. Okay, I can't type anything to the chat bar. Yeah, we're gonna see what we can do with a replay. Just try to stay on the webinar if you can, because it's possible some of the material we might hit a max recording and the stuff at the end might not get recorded. How will this benefit me in court case? Okay, like I said, we want to teach the material and go through specifically the understanding of the documents on the screen and the concept and the process. We can ask specific questions like, how does this relate? How can this help with that? You know, mostly at the end, and I will stay up as late as you guys want to stay up to answer all those questions at the end. This will benefit you in a court case, and if you're in jail and prison. If you were in jail or prison, you can win millions of dollars in a common law tort claim. Make sure you check the material out on the website about the common law tort claim under the product section. But you need to do this process first. This is the first underlying step, okay? Because you don't have common law. Again, the government has the legal title to that constructive trust, and unless the idea and what we're doing here is we're converting the constructive trust into a express trust, appointing the parties, having the proper documentation and meeting of the minds that document so that you can prove and show, and you can even include a lot of these on your UCC1 to show that the trust did have a meeting, there was a bill of sale, there were witnesses, there are beneficiaries, you got your certified mail that you sent, the certificate unit, which is this, right? And this is unsigned version, obviously. But it says, pursuant to the contract dated so-and-so, creating the above said pure trust organization and in compliance with all terms and conditions contained thereof, Dylan Smith, that's who this trust named as a beneficiary, holds 25% of Mark John Smith Trust, copyright, trust certificate unit, subject to the following provisions, terms, and conditions. The holder shall be entitled to a proportionate share of all distributions declared and made by the trustees in the ordinary course of business or upon liquidation of the trust organization. All units are fully paid and non-accessible when issued, and no liability for the actions of the trust or trustees shall inure to the holder. The holder shall have no rights, powers, or privileges or interests or in or control over the assets or management of this trust organization. The holder can only transfer these units in compliance with the restrictions, terms, and conditions set forth in the Declaration of Trust. A transfer must be expressly endorsed and provided below. Now, so who's setting all these terms? You know, the legal title holder. It's just like the DMV saying, you know, you got to drive the speed limit, you got to get your thing inspected every couple of years, right? We're issuing a certificate, but we're telling the certificate holder what the terms and conditions are, okay? The certificate is signed and dated. It becomes null and void, no force and effect at the death of the lawful holder of record. Deed of transfer. So yeah, I mean, the certificate holder is a holder in due course of this certificate, but it doesn't mean that they have a legal interest in the trust whatsoever. And if you read this notice to and so there's a witness, exchanger, so on and so forth. I want to read the notice because this kind of puts in perspective of what you're doing here. You do not. Okay, so here the trustee of the trust and says you do not have to do anything to accept this position. I mean, excuse me. This is a letter. Let me backtrack. This is a letter to the beneficiary. Okay, you can have one or more beneficiaries. It says this is a notice to inform you that Mark Johns of the family Smith has executed an express, what do we want to put in there, a irrevocable express trust on so-and-so date naming you as beneficiary. The trustees of the trust are Mark John Smith at this address and Susie Smith at this address. You do not have to do anything to accept this position. Please see the enclosed certificate unit 001. And that would be this, or whatever number, whatever unique identifying number you want to put on it. I don't know if this one has a unique identifying number on it, so you may want to add that. I actually don't see one on here. So that is something that needs to be added. You should keep this certificate in a safe place, as this is proof of your interest in the trust. Again, if you're issued a certificate of title for your car, you're going to keep it in a safe place, are you not, to prove your equitable interest. By accepting the TCUs and this notice, you agree to be bound by the terms of this notice. Number one, the exclusive venue and jurisdiction governing law for Mark John Smith Trust is American common law, with no regard to laws governing conflict of laws. What that means is if there's any conflict about what law governs, because the beneficiary is in the United States and the trust is in the common law, there's no regard to any laws that govern the conflict of laws, meaning it's going to be governed exclusively by the American common law, okay, or whatever law form that you want to choose to put in here, private, international, commercial law, whatever, okay. The exclusive form of adjudication for any and all claims through Mark John Smith Trust is Best Guy Trust Protector Services, Inc. That's just a random trust protector company that I made up as the exclusive adjudicator as identified in the Declaration of Trust. So again, we're not just making this stuff up. It's all governed by the Declaration of Trust or the trust indenture, okay? So in other words, if the beneficiary wants to, has a dispute, a claim, believes they have a claim, some dispute over their position in the trust, they believe that they're entitled to more money that the trust is supposed to give to them, they could raise claims and disputes, but it's going to have to be governed under American common law, and it's going to have to go, the exclusive form of adjudication is going to have to go through Best Guy Trust Protector Services, Inc. Okay? You can pick an individual, a friend that you trust. You can pick you can pick understand contract law if you want us to be your trust protector for your trust. This is usually not going to really ever be an issue because you're selecting who your beneficiaries are. So you're going to select family members like your children or your kids, or someone who's not going to become a hostile beneficiary and try to sue you to collect the money that's in the trust, because they're not necessarily entitled to the money that's in the trust, or might be entitled to some beneficial positions and maybe some distributions, but we'll get to that in the rest of this letter. Okay. So whatever the trust protector is, it can be an individual, a company, a trust, whatever, acting as the exclusive adjudicator as identified in the Declaration of Trust. You hereby waive the right to use any statutory public court or venue for raising or settling any claims or disputes arising from your acceptance of this beneficial position, unless agreed to by both trustees in writing. So that means if you choose to bring this into a statutory public court because you feel it will help you in your favor, then the two trustees can change that clause in writing. You agree that breach of this clause by opening any lawsuit against the trust or trustees shall constitute a fine of $500,000. for each instance, plus any other actual damages. And here we go. Here's the bottom line. You may waive your beneficial position in the trust at any time by providing written notice to either of the two trustees listed above. The trustee cannot make distribution to you until you returned a signed copy of this letter, which is down below here. I, Dylan Smith, have read the above letter and accept the distribution terms of the trust presented here. Signature date. Okay, but you notice at the top it says you do not have to do anything to accept this position. Their acceptance of the money, the certificate, right, is the consideration. You guys have all heard contract law. If you send an instrument and the other person keeps it, is there a contract, right? Haven't they accepted that? I'm sure you guys have learned that through, you know, Creditors in Commerce, Winston Trout audios, some of our material, our YouTube stuff. If you send them the money and they keep it, right? So you might want to have your third-party witness mail it, certify affidavit of what was put into the envelope. You might want to have your certified or registered mail, proof of signature, green card receipt. You might want to even put on that green return receipt, Dylan Smith, beneficiary of Mark John Smith Trust. Now they sign for that. They're signing in that capacity, and you're getting that green card returned with their signature on it, with the stamp of the post office showing that it has been delivered, and you've got a contract, and you can scan that green card receipt into the back of your UCC1 as an attachment to show that you've put together this trust and that you have appointed other people beneficiaries, or other corporations or other persons as beneficiaries, and they have accepted that. Now you've got indisputable, irrefutable truth that you have waived your beneficial position. So later on, when you do the process notification of record, where you send to the Secretary of State letting them know that you are no longer the beneficiary, the government is no longer the trustee of John Henry Doe, you've taken control, you've taken legal title. This is one of the notices that you send, okay? And you're sending it to two Secretary of States, the IRS, and what is the other one? Department of the Treasury, okay, to update your status. Okay, those are the main places to send it to. You don't need to go overboard and send it to, you know, there was one guru that was like, oh, you're going to send it to all 20 different government agencies all over, attorney generals and this and that. You're just going to raise a lot of unnecessary red flags for you. We're just going to show you the ones that it's necessary from our point of view. Okay, so basically what this says is, regarding accounts or trusts under the sub-account of Social Security number and or birth certificate number / driver's license number / passport number. Dear Secretary of State Record Keeper, until recently I was unaware that there were affairs being managed on my behalf without my knowledge or consent that have been left improperly tended with atrocious results. Now it has come to my attention that matters are not being handled equitably. Matters regarding to what? I want to test you guys, because I can read stuff pretty fast and there's a lot to absorb here. What type of matters am I talking about? You're sending this to the Secretary of State after you've done, as you can see here, I've numbered, you know, the steps, and this is just step one. This whole page is really just one big step of like 6 or 7 or 8 steps. And you can even go beyond that, and you can expatriate, officially no longer be a citizen, completely remove your Social Security number, completely get, completely get expatriated. You can go as far as you want, okay? There's some disadvantages to jumping into that, because if you leave the country and you don't have your common law status completely set up, they won't let you come back in. So there's, a lot of people have different benefits, Social Security, different things like that. They may not want to go that whole route. But the secured party creditor process is the way that you can keep all the trust. The trust still has the beneficial use of the Social Security, because you're into a private contract with the government that you paid into Social Security. They're going to pay you back Social Security, okay? So it's okay to collect Social Security. It's the trust that's collecting Social Security. There's nothing wrong with that. So the secured party creditor process is good for everyone. It's not something where you have to give up any other benefits that the trust entity is expecting, or has, if you've already done your work where you're expecting a return, pensions, things like that. you can still get that, okay? So it's a process. This is why we cover it first. It's really the first process to move on to any further processes. So we're just going to talk about this process, because if you haven't completed this process, why talk about the further processes? Why talk about the expatriation process? Why talk about things that are 5 levels beyond and more experienced than where you need to be? This is the first process, the first step to get yourself set up and secured. And it's, as you can see in all these documents here, which I'm going to open up each and every one of them today, it's not just filing a UCC1. It's not just doing a security agreement and filing a UCC1. You must re-express the trust, so you're converting it from a constructive trust into an express trust, have all the documentation you need to have, beneficiaries appointed, registry of the trust certificate units, all of those things. Okay, you may want to get a separate EIN number, so now that even you got confirmation that the IRS recognizes this as an express irrevocable trust, express trust, okay? So you want to get as much evidence on your side as possible, so that if anyone tries to come in and say, well, we're the trustees, we're administrating this trust, you can say, now you're committing high fraud. And so they will back off and they won't do that. And guess what? When you do it properly, it works. It's not like a it's not like a merry-go-round, right? Necessarily, there are people, they still need to fight with court. But people win their cases if they stick with it. It's a process that works. Okay, they will lie to you. They will challenge you a little bit as well. I'm sure you guys expect that that's the case to an extent. Okay, when the stakes get high, but this is a process that works. I just really want you guys, because why should you listen to me? Why should you go through all the trouble of putting all these documents and things together? Okay, so that's why, is because it's just not something that we just came up with, like, some other stuff that's out there, which I'm not knocking some new theories and stuff that's out there. There's a lot of good stuff that's out there that you can incorporate those concepts. But I would make sure you get all your paperwork in order that changes your status to a trustee of a trust that doesn't have liability, that operates on behalf of beneficiaries, and now you can say, hey, I'm just doing my job. Okay, it's like an employee of Coca-Cola will never get convicted for Coca-Cola soft drinks causing people to have rotted teeth. Does that make sense, guys? Right? Any claims against Coca-Cola, lawsuits, whatever, civil, criminal, traffic tickets, whatever, the employee or a manager or an officer or director or the vice president or whatever of someone just working for Coca-Cola can't be personally liable for Coca-Cola products rotting someone's teeth. And that mother of that 8-year-old kid whose teeth rotted because he drank Coca-Cola every day wants to open up a lawsuit against Coca-Cola. You got to open up the lawsuit against Coca-Cola. You can't open up the lawsuit against the guy who sold you Coca-Cola or the guy who packages Coca-Cola into the boxes in the warehouse and ships them out. And you can't do it after the vice president or even the president. There's a separation of liability when you work for a corporation, as a group, as an organization. You're not liable. The corporation is liable. The corporation, it's a dead fiction. It's liable, not you. Okay? So that's exactly what we're doing here. And when you take control as a trustee, this is what you send to the Secretary of State and the other places. Okay? This is what you can send. This is what people send. This is the process. Until recently, I was unaware that there were affairs being managed on my behalf without my knowledge or consent that have been left properly tended to with atrocious results. Now that it has come to my attention that matters of the trust, right? Matters have not been handled equitably. Matters are not being handled with efficiency. In many respects, matters are not being taken care of at all. Usurpation of funds is occurring. There's rampant fraud and deceit. Positions of trustee have been left vacant or properly attenuated. I have waived beneficial position and interest to take a position of trustee to manage the affairs of the trust, Mark John Smith Trust, or whatever your legal name is, and full control forth hence as indicated and identified by the account numbers above. Please return all information to the address above if you have any on hand or is in your care to the trustee. All others are now barred from handling affairs in regards to Mark John Smith Trust. All contracts that are in existence for the trust are to be returned to the trustee within 30 days for management or shall be considered vitiated, nunc-pro-tunc, void from inception by the trust forth hence. Your prompt cooperation is greatly appreciated. Furthermore, this and all pertinent documentation has been filed as public record under necessity in the commercial registry of the state of whatever, under filing number, whatever. You're going to handwrite that in. For some reason this thing keeps popping up. All right. This is a notice and acceptance via your receipt of this mailing. If you feel this notice is in any way in error or disagree with the change in position, please feel free to rebut this notice with your concerns within 30 days, or it will stand as fact prima facie. Notice to agent, notice to principal, notice to principal is notice to agent. Trustee, secured party, Mark John of the Smith family, without prejudice, recourse, authorized representative, Mark John Smith Trust. So there's duplicate copies in this, in here. All right, so I'll just take a little breath there, see if we have any questions. Is anybody starting to get what the process here is? Does anybody have questions about specifically the material on the screen in particular? And there's hands raised, but they might be from a while ago. I want to find out if those people, all right, let's go down to the bottom. The beneficiary is not an exchanger in this kind of a trust. We've got, how do you go about the name of the express trust, says TJ. How go about the name? It's just your legal name with the word trust at the end. Does correcting your status automatically? Okay, correcting your status is a big umbrella. It depends what you do. There's 75,000 different things that you can do. Updating government records, changing your status to trustee, changing your status to grantor, you know, killing off the straw man, withdrawing the Social Security number. There's lots of things that you can do. Okay. What is correcting your status? This is just a series of some documents that you could do for the initial setup. The initial setup is something that, again, you're just changing your position of the trust. Okay, if you get that, you will be able to answer your own question when you ask, does it void things like the passport, driver's license, etc.? How would it void them if you're not rescinding or anything like that? You know, again, you're changing your position of the trust. Okay, that's like if you had a corporation that you were a shareholder of and you sold your stock and said, I don't want to be the shareholder anymore, I want to be the president of Coca-Cola. Does that in any way change any patents or copyrights or property or other employees or anything that Coca-Cola has? Does Coca-Cola's EIN number change? Does Coca-Cola's license to do business in whatever state change because you decided not to be a beneficiary or a shareholder and you decided to be a trustee or executive? Okay, let me say that one more time. If this was a corporation, if you were a shareholder and said, I don't want to be an owner, I want to be a director, I want to be a manager, I want to be a vice president of Coca-Cola, I want to control how things run here, not reap the beneficial position. I want to be the controller, have a controlling role. If you said, I don't want to be a shareholder, but I want to work for the company as a manager or as a director or as a president, how would that change any licenses, EIN numbers, or anything? Does that answer the question? Okay, if you get it, then you get it. Then you don't have questions. You know the answers to the questions if you get it. Okay, and I'm here to help you to get it. I'm not trying to. Sometimes I'm a little, sometimes forgive me, but my tone is a little like it comes off. I don't intend it, but sometimes I'm just very, it comes off as sometimes insulting. So I don't mean anything that way, but I'm trying to drill home a point to help because I'm sincere about wanting you guys to understand it. So if you understand what you're doing, waiving beneficial position, becoming trustee, then because this letter says everything. We don't have to go into anything else to get you to understand it. Just read this letter 50 times until you understand it. If you don't know what attenuated means, if you don't know what usurpation means, look them up in the dictionary. Understand every word on this notice, and you will get this process. It's really broken down this simply. This is really just the one-page cliff notes of this initial setup. You can correct status 1,000 other different ways based on your needs and your preferences and your knowledge and how you might be able to update different government records or whatever on your own or whatever your scenario is. That's up to you. That's additional stuff that we go over so that you can pick and choose or just digest the knowledge and digest the, being exposed to the material and the concepts and the ideas. So if you're really interested in learning every possible thing about status correction, and I'm not saying we know every single possible thing, but if you want a real comprehensive plethora, sign up for the status correction course. This, I'm just going to give to you the initial setup to introduce you to one significant layer of protection that no, you're not giving up Social Security, no, you're not giving up the driver's license, no, you're not giving up the passport. Okay, so if that makes sense, I hope you guys are getting that of what this does. I know it's a lot to take in, so I'll work with you guys. Someone asked, yeah, a trust files a trust if it's in the U.S. files a 1041. Okay, so if you do this, you have to really understand what you're doing. That this is a trust. You have to know in your core that the name is a trust, and you're not. If you're filing taxes, you're not filing 1040s. You're filing 1041s. Have you ever looked at a 1041 before? Are you planning on filing 1041s if you're filing taxes, if you're liable to, and obligated to file taxes, or you think it's a good idea to do so? You can't do this. Don't do these documents unless you're going to do 1041s instead of 1040s. Unless you really believe and know that it is a trust. So very good question, David. He asked about the 1041. And yeah, people have been filing 1041s after they've done this for, 10, 15 years. I am not aware of anyone that's, like gotten in trouble. If you're questioned about it, well, why are you filing 1041s? Well, because it's a trust. So you got to really know the stuff. That's why we do a whole week by week course to give people glossary of definitions, study partners, answering people's questions for 3, 4, 5 hours until people don't have any more questions, giving people downloads, giving people stuff to study. This is why we go into this. And I try to leave as much fluff out and only give, the material that is necessary to understand the concept. You can always go back in later, rewatch the stuff. You have a lifetime, if you get the status correction course, you have a lifetime license to all the materials. You can watch them at any given point in time and for the next 99 years, okay? So we will maintain those files for you in a way where you can re-download them anytime you want, or you can access them on a private membership. You can with a login and password, which we're going to get in the next couple of months. We're going to set it up with a private membership through the website, so that you can absorb all this material and get the overstanding of it. Okay, because you can't just go and run file documents without really believing in them. Okay, anything you sign your name to, you should research and understand what every word means. Or just take the course for entertainment for now, or for study, and think about if you want to do it at some point in the future. You have to start learning sometime, right? Don't you take a driver's ed course for a while and you do the in the classroom stuff for like many weeks before you actually go out and start getting in a car and doing the test driving in the parking lot? It's the same thing with anything. If you care about your freedom, if you care about changing your status from not being, the property and the beneficiary and having the government be the trustees, if you want to change that, how much do you really care? Are you going to study, or are you going to watch, Big Bang Theory for 3 hours a night on Friday night? Which I admit, it's a very entertaining show. I like the show. But when push comes to shove, when I know I have to study stuff and it's important to obtain freedom, I'd rather spend those 3 hours studying the materials, regurgitating it, putting it into PowerPoints, and preparing for the status correction course, because when I know I have to teach, I have to clear my plate off, I have to clear my desk off, and I have to take material, and I have to put it all together in a way that breaks it down so it's explainable to someone else. You learn the best when you are teaching. So if you saw on our website, we have one of the best ways to learn is to teach. So if any of you guys want to teach some of these concepts while you're studying and learning them yourself, you can actually get paid to put together PowerPoint presentations and convert them into webinars, and we'll pay you $1,000 a month to do a few presentations a month for us. So if you missed that, you must not be on our email list, or maybe you deleted the email because you got too busy, or you missed the blog post. So stay in tune with our email list. If the stuff's going into spam folder, whitelist us and make sure that we're in your contacts and we're not going in your spam folder. And then check out the blog roll on our website, frequently, because we add new stuff here and new services and things like that. So I will show you guys the secured party creditor form that you can fill out if you want to jump to getting your paperwork filed at any given point in time, because hey, I'm still learning the process, but I've done the filings, right? So you could still do the process while you're learning it. Okay, you're never completely done learning, right? You're always still in the learning mode. So we have a file here that you can download when you go to Products, SPC, UCC Filings, the first product, and it downloads to your computer, and you can open up and you can get a nice little form where you can fill out. You got to hit Enable Editing. You can fill out your information, and underneath the column it tells you exactly how to put secured party creditor first name. This is your name spelled with the first letter in caps and every other letter lowercase and then a hyphen, and then the middle name upper and lowercase with a colon, and then the last name or the family name. Okay, then you pick the domicile of the living man or woman. This is we suggest the common law state of your choosing. And then you pick a street address, city, state, zip. It gives you tips on, don't abbreviate the city, don't abbreviate the state, spell it out, and put the zip code in brackets for the secured party address. And then we give recommendations about getting an offshore foreign address, and we can refer you to a company that is in another country in the Caribbean that anybody looks at that address. And that's why on these documents here, the Mark John Smith, which is the secured party creditor, has an address in Nevis, the West Indies, because they're going to see that you're sending this from outside the United States. Okay? Whereas if you put an address with the zip code in brackets and write non-domestic, that's a way to say that you're in the common law, that you're still outside the United States, but it's a little bit more clear and more secure if you pick an address for the secured party to get mail that is offshore, like in the Caribbean or Latin America, or somewhere close by where you could, if it's important mail, get it forwarded to you. But there are receiverships that you can get mail from trusted sources of, friends of mine that run it, that will scan in any mail that they get, and you'll get it in an email notification in real time. Okay, and you're not going to get a lot of mail for the living man or woman. Okay, you want your mail, your email communications, you want all your dealings to be done through the all capital letters name. Okay, you don't want to be signing things as, this is the biggest mistake, in my opinion, it's a mistake. One of the biggest mistakes that people are doing right now is they're signing their names. People are mailing us donations and stuff, and they're signing their name in hyphens and colons and upper and lower case. Well, they're taking personal liability on the transaction that they're doing, right? You want the trust. You want to use the, okay, this is specifically because you're notifying from outside the United States that you, the living man, are doing this. So there's some capacity where you're sending this notice, but when you go off in the world, you're using this trust as a shield between any liability. The trust is the one contracting, not you, the living man or woman up here. Okay, so you're going to use the trust. You're going to use its social security identifying number. You're going to use its driver's license number, perhaps. You're going to use its name in all caps with the word trust in any contracts or dealings in order to absorb any potential liability onto the trust and not onto you, the living man or woman. Does that make sense? And do you guys see, or do you have a counterpoint? Do you guys want to debate? Does anybody have a good point to argue against what I'm saying? In other words, what I'm saying is you're not going to be signing your name hyphens and colons. You're going to be signing all caps in the real world because you want any potential liability to be put onto this trust. Why? Because the trust has two trustees, multiple beneficiaries. It's an organization. It's just like Coca-Cola. Right? Coca-Cola will sign the contracts, not the employees for Coca-Cola. Why would Coca-Cola ask its employee to sign a contract to absorb the liability? Why would you, as an employee of Coca-Cola, sign a contract? If anything, if you did sign your name on the contract like this, you would put as, and then you would put the capacity that you're signing as. Okay? So you might write by Mark-John Smith, comma, as trustee for Mark John Smith Trust, because the contract, you're the one executing the signature on behalf as the authorized representative for the all caps name Mark John Smith Trust. Okay, so you are not personally liable because you're signing in the capacity as a trustee of the trust, and so the trust absorbs the liability. And the trust is the one engaging in the contract, not you, the man or the woman. So I will open up for questions on that point. I'll try to get my special guest on the line in a minute. Okay, any docs that will be signed by a notary will say jurat on the bottom. None of these say jurat on the bottom. There are other documents that might say jurat on the bottom. Okay, breaks the presumption that the natural it's like going from sole proprietor to full liability, corporation protections on the same EIN. Brother, you're doing great. Thank you, Vince. Makes it a valid contract, just not a presumption. Yep. Separates paper from flesh. Yep. I'll read this letter till I get it. Yeah, I mean, guys, it took me a long time to get this. I know. I'm trying to break it down and provide tools and videos and trainings and Q&A because this is important stuff. Like when you help people get their paperwork in order and then win 6 and 7 figures in common law claim processes where they didn't have to go to court and they didn't have to hire attorneys and they won and they got paid, including from being arrested or beat up by cops. I mean, it's the most rewarding thing that you can do to help people win money for being injured or damaged, including if business partner ripped them off and stole money from you, stole intellectual property. Any way that you're injured in any way, you can do a common law tort claim. You just got to get this gotta get all this paperwork done, and right, in all this stuff. And so we put together a form that we can work with clients that want to, or members of the congregation once we convert into a ministry. But we're going to have people, fill out the material and then be able to get the 90 to 100 plus pages of templates. Like, these are only like a few pages. There's in total close to 100 pages, and there's a step-by-step order to filling it out and signing it. We're going to have a service where you can give us power of attorney in order to actually sign and execute all the stuff for you. But we actually prefer for you to learn it. We prefer to give you instructions. We prefer to give you training to learn it. But we are open to helping in any way that you would like to propose. If you're, like I said in the beginning, if you're appreciative, kind, and respectful and supportive of what we do, and, forgiving slightly to any faux pas or tardiness in hosting the webinar on time and things like that. Like, that's not, I hope most people understand that's not really what matters, that I was 10 minutes late to the webinar. If you do, then, I would challenge that guy to say, listen, you put all this together, you put a template together that fills out all the fields for people, you present and research and explain all the material and put it all together in the right order and teach it to people that don't understand it. You do it, and I'll pay to go on your webinar. But I doubt that guy who criticized me for being 10 minutes late on my own webinar is actually putting something together on his own. Is he hosting a webinar to bring people together, to teach people, to answer questions, to introduce people to other people? Like in our status correction course, you're going to get to know other people in the course. You're going to get to, that was one of the most beneficial things for me, and how I actually helped to bring people together to form the board of UCL, was that I went to a Mastery in Commerce course, and I met a whole bunch of like-minded people that were studying and committed and dedicated to the same stuff that I was. So we kind of, clicked and resonated and developed a friendship first, and then we became study partners, and we just exponentially expanded the knowledge, understanding, and evolution of what we were doing and what we were understanding, and how we're able to get successes. So one of the most beneficial things you can do is meet other like-minded people, which we give you an opportunity to do because we pair you up with a couple of study buddies, and you get study sessions, and you get the personal, you get to exchange contact information if you wish with other members of the group. Okay, so that can be very beneficial to you as well. So we need more people to be outdoing the stuff that I'm doing, or the stuff that I understand contract laws do. We need more people. You want to outdo this website with all the great, information and daily blog posts on it, and, detailed articles and 75 YouTube videos right now. You want to outdo it and explain stuff better and put better stuff that gets people better results. I applaud you. Please do it. Please do it. The world needs more. And there are some really other good stuff that's out there. There are some really other good sites that's out there. Freedom School, Creole Harmony. There's a lot of good stuff out there. Carl Lent. There's a lot of good stuff out there. Okay, I'm not trying to monopolize I'm not trying to monopolize everything. But if I have something that's good, I'm going to put time and dedication into it. I'm going to stay up for 14 hours in a row putting stuff together, like 5 days in a row, 3 weeks in a row, to get this done, because the world needs this. The world needs people to change their status, to become free, to have more options, and to no longer have that liability and control over their estate, over their life. So we put this together to make it easy for people to just fill out the information, and then you will get all these templates and more pre-filled out with your second trustee and their address already populated into the field, the name of your trust populated in all the right places, your address populated in the right place, your account number, social security number, etc. But you don't need to. You could do it yourself. You could do it yourself, and I recommend you do it yourself if you can. But if you need help, we are available, and we are in the process of training people to learn this correctly, learn how to spot check the documents and prepare them, and help larger amounts of people. So if you are interested in doing that, first off, sign up for the status correction course, because that is the training that you will get, and then if you graduate from that course, you can get paid to do processes for people if there's a demand for it. Okay, so, and there is a demand for it. There's going to be a big demand for it in 2015, because we're going to be hosting a lot of webinars going over this process, and this webinar is packed out 100 people. There were 200 people trying to get on, and well, let's see. No, I'm not. I can't go back there. You know, so we're planning on doing this next week and the week after, and every single week, to have webinars with 100 people packed on. So there will be people wanting to, you know, the small portion of people that, or I don't know how many people, but the people that want to, you know, contribute a donation to get some services done in exchange, is expected to grow. Okay, so what you're going to do is put your information, and you could also use this sheet for your own. You know, I use this sheet for my family, my friends, the people that I'm helping, to collect their information and put it together. So, second trustee is the one who you trust deeply, who will have your back and not back down to protect the trust. The first and second trustee need to be competent trustees, and or at least be committed to learning about being a good trustee, and in the mode of, you know, quickly learning to do so. The second trustee position is extremely important. God forbid they were ever questioned about it and they backed down and said, no, I have no involvement, I don't know what you're talking about. That would completely potentially vitiate your trust, put you back into the old straw man status of you being the in persona conjuncta. So you really need your second trustee to back you up. Exchanger could be the first or second trustee or another party of your choosing. That's pretty simple. Some piece of property you put into the trust. You could put a gold coin, you could put a ring, you could put you could put anything, tangible or intangible. Okay, but there needs to be that exchange, just like in a marriage. Why do they want people to exchange the rings? Because it's something tangible. Something tangible that it's exchanged with a witness creates a really solid contract. Now you can't go back and say, oh, I'm rescinding that contract. At least you can't do it that easily. You see what I'm saying? So people get hung up on these things like, well, what's the property to put into the trust? Dude, you could pick anything. You could pick a pencil. You could really pick anything. You could pick a pencil. You could pick, I don't know, anything. Anything that you own, okay? Right? You have to have free and clear title to it. Okay? So, you know, I was thinking, oh, go pick up a rock on the street and use that. Well, do you really have the title to that rock? Where do you live? Do you live in a private community? You know, do you live in a condominium-like development and all the grass and the rocks and pieces of the concrete from the road that break off? Who really owns that? You can't just pick it up and say you own it. You see what I'm saying? So, or if you took a pine cone from the forest, well, if that was a state park, you know, maybe the state has a claim on that. So you should really pick a piece of property that you really paid for, free and clear, that you actually that the exchanger actually owns, and can document that they own, if ever questioned about it, you know, retroactively. Okay. Don't pick a house. Don't pick real estate. Okay? That's not what you're doing with this trust. You want to pick something you own free and clear. Number one, you don't own that free and clear because you probably got a mortgage and property taxes and things like that on that. Okay? Pick something smaller. There's certain reasons why you don't want to put, you know, real estate into this trust anyway, even if it was appropriate. This is just a trust to create an express trust for your legal name. This is not a trust to put large amounts of assets that have a high value. Okay, those would be, you probably want to set up like a land trust for something like that. That'll be the subject of future things. But, you this gives you all the fields, the governing law of the debtor, the date you were born, the date of your 18th birthday, a second notification state of that, where you're going to send this notice to. You're going to notify the Secretary of State in the state that you were born in, and the Secretary of State in another state, preferably, a state that you live in if it's different than that you live at, if it's different than the one that you were born in. Those would be two really good states to notify. Okay, so what do you got here? Exchanger, the beneficiaries, the percent that you give to the beneficiaries. So you don't need to give 100% to the beneficiary or beneficiaries. Okay, a corporation can issue stock, and you can just issue a certain amount of stock, and you can hold, and you can always issue future stock, years later, right? So you don't need to issue all the stock of the company like all up front. You can issue a portion of it, and then you have reserves for issuing more at a later date. Okay, so a trust is very similar to a corporation in the fact that the beneficiaries are kind of like the shareholders of a corporation. Trustees are kind of like the directors of a corporation, or the president, vice president, and the founder of a corporation, like whoever founded the company, is the grantor or the creator of a trust. And the investor that also helped create the corporation, right? Usually the founder and investor, right? Like I think that the founder and investor of Microsoft is probably like Bill Gates, right? And the founder and one of the investors of Facebook is Mark Zuckerberg, right? But it doesn't have to be the same person. You can have one person put up the money or property and one person be the brains behind it, right? So the exchanger of a trust is kind of like the investor of a corporation. The creator or grantor of a trust is kind of like the founder of a corporation. So I think I went over all the parties there and how a trust is very similar to a corporation, but it has way major advantages. But again, we're not really focusing on the advantages of using trusts, other than the fact that we are limiting that liability, creating some different things that we can go after, some different protections that we have, and you got to pick one of the main things is picking a really competent second trustee, and having a second trustee, and having board meetings with your second trustee, even if it's just once every 2 years. You got to document and show the meeting minutes and the cooperation and involvement of the two trustees. I mean, it's private. You don't have to share that knowledge with anyone. If a court asks for it, it's private. You don't have to show it. But the trust and the board of directors may want to show that they're, to prove that it is a valid trust, if it's to the advantage of the trust, okay? So if push comes to shove, years later down the road, it's kind of like when you run a company. Years later down the road, you're going to get audited for the things that you're doing years ago in the initial setup. So you want to make sure you do whatever you do in the initial setup properly from day one, right? You don't want to be sloppy with your bookkeeping and your records and this and that, and then get audited for something you did 3 or 4 years ago that wasn't proper. Okay. Same thing with this. You want to have actual board meetings. There's really just one meeting. It's only 10 minutes long. I have a script that I can read to you of a sample of exactly what to say at the meeting, because I understand people haven't done these things before. They've never had a trust. They've never been on a board of. Maybe when you guys are in college, you were on the board of your student government, or on the board of some sorority or fraternity, frat group, or some club in grade school. I don't know. But if you never formally had a board meeting, you may want to learn how to do that and what the rules are. There's something called Robert's Rules of Order that you may want to look into. But even that, you don't really need to study really that hard. I put together a script which is sufficient for the topics and the bullet points of what to cover at the board meeting. Let me just pull up the first board meeting, minutes of initial trust. This is just a document, the date of the meeting, the place of the meeting. Now it can be done through Skype, through the telephone, through whatever, okay, but you could be done at a Starbucks, at a library, it could be done at your home, whatever. But you got to document that a meeting of the minds actually happened. You're not just putting this paperwork together and signing this stuff. You're just documenting that it happened. The first trustee, in case it ever gets questioned and you need to relinquish any doubts from some judge or whoever that this is a express operating legit trust. A lot of trusts have been, and corporations have been determined that they were a sham and that it was really just one person operating it, and they were using a fictitious trust or sham corporation as a shield for whatever purpose, okay? So doing things proper, I'm a big believer in doing things proper. First trustee, Mark John Smith of the aforementioned trust, was present and constituted a quorum of the board. Trustee called the meeting to order and affirmed that officially on so-and-so date the trust was created but left properly unmanaged. That's the date of the date of birth, right? Trustee called the meeting to order and affirmed that officially on so-and-so date the trust was created but left properly unmanaged until today's date, until accepted by appointment of Mark John Smith has been accepted as first trustee of the trust. Trust became fully operational as a separate legal entity on the birth date. Temporary secretary, as undersigned below, was appointed to record these minutes. Trustee approved the initial exchange on the attached addendum to the initial meeting and authorized the issuing of the agreed number of certificates to the exchangers. We showed you those already. Trustee then appointed Susie Smith, another trustee, and the party being present accepted the appointment and affixed her signature below. Trustee stated that the trust was in immediate need of a person or persons who could serve as managing directors. After discussion upon motion duly made, second and carried, it was resolved that the following person or persons herein named as officers of the trust to serve with bond and until replaced by resolution of the Board of Trustees in the capacities identified below. You and your second trustee. It says managing director and secretary. Those are both trustee positions. It is decided that the managing directors will be authorized to conduct day-to-day routine business of the board, to hold trust business meetings, blah, 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 have bank accounts, yada, yada. The secretary will keep minutes, act in the best interest of the trust certificate holders by keeping prudent record keeping of certificate transfers and other business respecting the holders of this trust, etc., etc., etc. There being no more business before the board, the meeting was adjourned. The two trustees. So did you actually have a meeting and have a motion that was second and carried and the board resolved that you were both appointed as the trustees? Okay, did you actually do that? Well, you may be unfamiliar with doing that, so what I did is I put together a sample script. This is a sample of what to say verbally together with the two trustees at the time, date, location of the first trustee meeting. Let me zoom in a little bit. I hope you guys see the amount of time that we put into making things easy for you. It is a sample based on the agenda that your first trust meeting is usually going to have. You can have this meeting on the phone at a physical location together through Skype or join.me or any other means. You may wish to have your meeting using an encrypted or private technology, which we're going to have future webinars about. Well, basically, if you're using the phones or the internet, there are tools that you can keep all your trust meeting minutes private so that you don't have, I'm sure you guys know the CIA is recording, everything that we're saying right now, and everything on your phone, and there's, buzzwords that are caught and things like that. So if you guys are into this stuff, you're probably all having your stuff, monitored by the CIA or the NSA or whatever. So, not that you're doing anything with your trust that you really, have any liability about, but, hey, I don't want other people, this is a private meeting, I don't want anybody listening to it. So there is some really cheap, very effective private technology that you can use if you're going to have your meetings over the telephone or over the computer or whatever, and we're going to give you tools for that later. Military-grade encryption text messages and sending photos through phones and encrypted phone calls that nobody can intercept. Really cool stuff like that later on in the year we'll put some webinars together for you guys. But that's not necessary. We like going above and beyond right? And giving you all the tools and ammunition, and you guys pick and choose what you want. It's like a buffet. We like going above and beyond so that everybody who comes to the table, if they're really hungry, if they're a meat eater, if they're a vegetarian, if they want soup, if they want a salad, if they want Indian food, if they want Asian food, we want to bring everything to the table, right? Every kind of drink. You want, fresh squeezed carrot juice, wheatgrass. You want iced tea. You want soda. You want to drink Coca-Cola. We want to bring everything to the table and go above and beyond what is necessary, because we're just very passionate about this stuff. This is the real deal here. So why not go above and beyond? I wouldn't go above and beyond if this was nonsense, if this was a theory that some guru started talking about, 3, 4, 5 months ago and posting up videos on the internet. I'm passionate about this because I know that this process works. Okay, I know this is the correct process. I know for me, from what I experience, and there's many different ways to do things. So if you have other ways and other things that are working, please share them with the congregation, share them with the family, share them with us, and we would love to pay you to write blog posts on our website. We would love to pay you to make PowerPoint presentations. We would love to pay you to do webinar presentations if it's really good stuff, if it's valuable stuff. Okay? Focus doesn't all have to be on me and my guys doing webinars. Okay? So it's a cooperative effort to an extent if you guys are at that level yet. Okay? And I welcome you to elevate to get to that level if you're not. And I hope that I'm facilitating that in some way. Okay, so anyways, calling to order the Mark John. This is a sample of the script, okay? So you would sit down, preferably in real life, because then you can sign the documents and get both wedding signatures on all the documents together all in one meeting, okay? So this is how it would go. And this is really important. I know it's starting to get a little bit to the late. We're going to be wrapping it up within the next 20, 30 minutes. And then I'll just take questions for whoever really wants to stay up late with me. And I know I will probably have to wake up late tomorrow from staying up late and talking. It's a lot of energy to keep talking for hours and hours and answer questions. But, this stuff is important. It's really important, okay? So this is a sample of what the meeting. You sit down, you got all the documents printed out that we prepared for you or that you prepared for yourself, and you go, calling to order the Mark John Smith Trust. Today is Friday, January 30th, 2014. Who is going to take the meeting minutes as the temporary secretary for today? And then obviously you or your friend would raise their hand and say, okay, you're going to do it? Okay, great. You pull out your marbled notebook, or you pull out whatever, or you pull out the previous minutes that we already have typed up for you, and you just document and, put a check mark next to the fact that this all happened. And at the end you sign it, okay? So we're going to go. We're going to say, present here are myself, Mark John of the family Smith, and Mark Dennis Awesome, who's your second trustee. I, Mark John of the family Smith, will act as the chairperson of this meeting, and Mark Dennis Awesome, will you act as the secretary and record the meeting minutes? Okay, great. We have a consensus. Okay. Now the first order of business. The first order of business is and the whole purpose of this meeting is the mismanagement of this trust and the reorganization and proper management of this trust at the direction of the creator or of the grantor, which is me in my sui juris capacity. So let's just give a little bit of background, make sure we both understand what's going on here. The trust, I have the birth certificate right here. You might want to pull out a certified copy of the birth certificate, and you might want to show the second trustee. You want to say, listen, I have this birth certificate right here, and this trust, obviously, it's a legal entity, operating in the United States and so forth, and it became fully operational as a separate legal entity on whatever your birth date is, as evidenced by the birth certificate. Right here is the birth certificate number. And here's a certified copy that will remain in the trust books and records, and we'll let the secretary keep that in their trust books and records. By the way, 3-ring binder with clear plastic sheets. That's your trust books and records, okay, in case you guys know. So go pick one up. Go to Staples, okay? I frequent Staples all the time, okay, because I'm a trust geek. Okay, I am a trust geek. I got multitudes of trusts that I'm in some way involved with, okay? So you're going to put that birth certificate in the records there, okay? And yes, you can go and get the authenticated and apostilled copy and put it in there. And we'll cover that at a future webinar. We're not going to go there yet, but this is just to show the second trustee. Here's the legal evidence for identification purposes that this trust exists. But you know what? The government's running this show. It's being mismanaged, And since it's me that created it, we all know that from common sense. It was my foot put on the birth certificate. I mean, we know that. We're having a meeting. We're having a meeting of the mind. We're both explaining. We're both understanding it. Listen, we're going to change and reorganize this trust due to the mismanagement of the corporation, the federal corporation, mismanaging it. So you're going to say, here's a certified copy which will remain in the addendum and the trust official books and records attached here too. Background. The trust has become fully operational as a separate legal entity. Did we copy that already? Okay, that's a duplicate. We already said that in the previous, look, we're saying this twice. I'm going to update the file here. So as John Henry of the family of the House of Doe and the creator and grantor of the trust John Henry Doe, let us affirm on and for the record that the trust has been left properly unmanaged and that I am appointing myself, John Henry of Doe, of the family Doe, as the first trustee of the trust. Due to the fraud and deceit involved in the mismanagement of the trust, and based upon my own sui juris capacity as the creator, I have enrolled, well, this is, where we change that, I have enrolled Mark Dennis Awesome, and by the way, if your second trustee can be a U.S. citizen, it doesn't have to be a living man or woman, okay, it could also be a corporation, but you shouldn't be involved with that a corporation, okay, if you have a second or third trustee or whatever, you shouldn't be involved with that trust or corporation. You want to really create a separation. Otherwise, they can pierce the corporate veil because it's just you and another capacity being the two trustees, and then they can break that. So the bottom line is you got to have a friend that wants to be your second trustee, okay? And that's not difficult. I mean, I was laughing with my mentor the other day about this, and he asked me, he's like, I said, there's some people who say, oh, I don't have a second trustee. And he goes, what, you don't have a friend? You don't have one friend? Really? You don't have one friend? Okay, so you got one friend that's the second trustee. Obviously, you want to pick the best, competent, attention to detail, sharp, intelligent, trustworthy, loyal, dedicated. If you went to prison, they would come and visit you type of friend, okay? And they wouldn't abandon you, and they wouldn't just go on with their merry life, okay? Second trustee, okay? Some people have questions. Can my spouse be my second trustee and all these things? We get into all those details later in the status correction course and in the later materials and stuff. I just want to go through this script right now, but there's some legitimate questions that come up that people have. Once we have two trustees, okay, so picking up the script here, we have enrolled Mark Dennis Awesome to consider a position as a second trustee of said trust here today. Once we have two trustees, now we have formalized that. Once we both sign our acceptance as trustee documents, we can conduct further business of the trust today. Mark Dennis Awesome, as your role as trustee, you must pledge and manage to protect and preserve the trust estate to the prudent exercise of the powers and authorities provided to you by the trust, i.e. contract, the declaration of trust. All actions by the trustees must have a consensus of the majority of the Board of Trustees. Mark Dennis Awesome, please review and sign the acceptance as trustee position paperwork, which is a one-page just acceptance that they're accepting that role. Do you wish to accept this position? They will say yes. Well, then raise your right hand and repeat after me. I, Mark Dennis Awesome, and then he says, I, Mark Dennis Awesome, solemnly pledge to manage, protect and preserve the trust estate, through the prudent exercise of the powers and authorities, provided to me by this contract, titled Declaration of Trust of John Henry Doe Trust. What was the trust name? It wasn't John Henry Doe Trust. It was what was it? What was it, guys? Mark John Smith, right? We used. So let me fix that in this script. Right? This is a example of a fake client or person doing it, or usually we use John Henry Doe. Oh, here's another one, John Henry Doe. Just want to make sure it's congruent. We're going to have both. Why don't we make this one John Henry Doe? That's fine. You guys get the point, right? Okay, great. We'll put today's date on the acceptance as trustee. Make a copy for your records. You can sign it. And we'll keep the original in the trust meeting minutes in this 3-ring binder here, this books and records. You might want to have it. We have a nice cover page, by the way, for your 3-ring binder, and I'll show you what it looks like. We got everything for you guys, and we're continually working. I work 7 days a week, 12 hours a day minimal. I don't have a weekend. Okay, this is my life. So, and sometimes I'll take a day off like once a month or something like that, or go on like a, once a year I'll go on like a 3 or 5 day cruise or something like that when I'm able to. But I don't really, maybe it's not correct because of the whole biblical thing where you're supposed to take Saturday off for the Sabbath, and I don't know how my life would be different if I did that, but I definitely break that rule. For good or for worse, just to let you guys know, where is the cover page? Here you go. This is a cover page. So you would put this document, Mark John Smith Trust Documents, created by Mark John Smith, main office, phone number, email, right? So this is just going to be on the cover of your 3-ring binder. So go to Staples, go to Office Max, go to even, there's a lot of 24-hour CVS stores, and you can get a 3-ring binder from there if it's like at the end of the webinar, if it's like 1 in the morning. I've done that many times. I just go to CVS because, the Staples closes a little early. But I go there, and you get your special paper, you get your special binders, you get your special, whatever you need, staplers, you need, blue ink pens, markers, highlight, all those office supplies and stuff, envelopes, all those things, bubble wrap. But this is a nice little cover page that you can put on the outside cover. That outside cover, you can slip it underneath there so that when you leave this around your house or you leave this around wherever you bring it, wherever you store it, you can identify that that's your binder for this trust. You're not putting any other stuff in there. That's your binder for the trust. Okay, and it could be interpreted that if you have your trust documents in a binder along with like your homework for going to grad school to learn to be an engineer or a doctor, and you're mixing those two things together, potentially, or you're mixing like another corporation's documents together with this trust documents, with you got 3 trusts put together in the same binder, mixing and matching it together like that could be construed like it's your personal property, and you're mixing and matching your own personal property with your position as a trustee of this organization. So you want to keep it separate by itself, where you've only got the clear plastic sheets with the 3-ring binder, you've only got your trust documents exclusively in the binder, and you have it somewhere in safekeeping. And you may want to put it in a safe, a fireproof safe, things like that. You might want to make second copies of all the paperwork and keep it in a safety deposit box, or keep it at your like at your mother or your family member, your mother or father's house, or somewhere else, just in case it gets stolen, just in case your house gets raided and it gets taken, or your house goes on fire, or there's an earthquake, or there's a hurricane, or you get into a disagreement with someone and they steal documents from you, or you get evicted and they lock you out of your house. Whatever this scenario is, this is critically important stuff here, okay? This is like, keeping stocks and bonds that you inherited from your grandparents, or that you're not supposed you're not supposed to cash or deposit for like another 10, 20 years. Like, this is valuable stuff that you need to treat it like that valuable, because it is. It really is extremely, extremely valuable. So I use this cover sheet in order to document that that's my 3-ring binder for the trust. And I don't have it under safekeeping right now because I'm working on it still, and I'm putting extra stuff in there, and I'm going through and making amendments to and adding different meetings and stuff that we're doing. So, I have it out in the open now, but when you're done with it and you don't need to really have additional board meetings until issues come up, which you might have 2, 3, 4 years in a row where you don't really need any board meetings. Okay, you might want to have maybe like 1 meeting a year just to document that you had a meeting, you discussed that there was no important business to discuss. Everyone is going to renew their positions as trustees, and everything is going to go smoothly, and no, we're not paying the beneficiaries yet, or we are paying the beneficiaries, or whatever this case is. You may want to just have some documentation. Once a year is a good rule, and instead of just having a trust on the shelf for 5 or 10 years, it could be interpreted like it's not a real trust, okay? But you set it aside and put it under safekeeping when you're done formalizing everything, and you don't plan on having a meeting for a while. Keep it under safekeeping, and don't leave it around for people, the dog to eat it. Do you guys do that with your homework? You leave it around for the dog to eat, and then you go to school and you're like, the dog ate my homework, and that's the oldest excuse in the book. So don't go running into a courtroom and telling the judge, well, I had this private express trust, but the dog ate it. Keep it under safekeeping, guys. Come on, this is critical stuff. This is critical stuff here, okay? And you could put the passport, right, in that too. Any other important documents for the trust, right? That's the trust's like identification, right? The passport, obviously, I'm sure you guys keep your driver's license and stuff in your wallet and stuff, but now you know where it is. Your passport and other identifying information like that. You're keeping all that in one place, so you can keep stuff like that in there. Anything related to this, bank account information for Mark John Smith Trust, etc. So this is a nice little cover sheet. It's nice and pretty. You could design one on your own. Okay, you don't need our documents. You can design one on your own. Have fun with it. Have a trust party. Have popcorn. Have some wine. Put on some music in the background. The number one way you guys can be successful, I think, over the term is to develop friendships. Meet like-minded people is really something that I think that the majority of people that are studying this kind of material are missing. They're not really making an effort to go out there and meet like-minded people. So we hope to be changing that in 2015 and help to be connecting people who live in the same area that are on our multi-thousand name-long contact membership list. Okay, so we really want to help make an impact on your life in many ways. Okay, so anyways, this is just like something that you could put on the back of it, or when you open the first page, the first little sheet might say this: identification of parties, creator, funder, exchanger, trustee, secretary, just so that you know. Like if this is new to you and you're creating your first trust, just so that you know. Because over time you might have 5 or 10 trusts, right? And once you learn this once, you get it. It's second nature. So if you guys are taking a lot of this in, this is a trust for a specific purpose, but you can duplicate and change and edit these templates. There's going to be different templates for different declarations of trust, for different purposes: land trusts for real estate, business trusts for running businesses through. There's different kinds: holding trusts for holding large amounts of assets in the common law, gold and silver, etc. There's lots of things that you can do. Once you learn the trust game, you can do a lot of really cool stuff. But the trust game is important because, again, your legal name is a trust, and you got to take control of your legal name before you ever do that UCC1 stuff and all these stuff after that, which we're not going to have time to cover this week, but we'll cover some of it next week, and we'll open it up. We'll hope to have next week we won't be blocking the 102nd person off the webinar. I really feel I didn't expect that to happen. So next week hopefully we'll have 200 people on the webinar. Okay, that would be really neat. So let me get back to the script, and then we'll try to wrap things up, and we'll just pick up over the next 2-3 weeks, and we'll give you guys an opportunity to get this first step cemented in your head. And of course, if you guys want to contribute and support what we do, we have a status correction course. Make sure you just give us a call during the day. Go to the website, click around it, read about it. If you really want to go into hardcore with the full process and all that's involved with it, and become a student, and then be applicable to be an apprentice that gets paid as an intern to work with our clients to do these processes for them, then you definitely want to sign up for our status correction course and do a little catch up, because we're already 5 weeks into it. But this is all the material that we teach. This is an overview of a lot of different processes. We're just covering the initial trust process. This is some additional information and so on and so forth about it. But you can call the number and talk with Jay about it, and he'll give you the particulars and so on and so forth. So let me finish the script. Okay, great. Put today's date. Okay, so you got your second trustee to solemnly pledge. Raise the right hand. Now, do you have to do this? What do you guys think? Do you have to have each trustee swear in to pledge? I solemnly pledge to manage, protect, and preserve the trust estate through the prudent exercise of powers and authorities provided to me by this contract. Declaration of Trust, John Henry Doe Trust. Let me see what you guys think. Do you guys think that it's mandatory to do that? I have my opinion about that. Wow, we got a lot of questions here. Oh yeah, special guest. He was supposed to call in. I'm kind of on a roll here going over this stuff, so I'm not going to call him. Next week for sure. Next week for sure. We're going to have a special guest on that's going to co-host with me. Oath and swearing is contract must do. Or affirming. You don't have to swear. You know, some people religiously, they're against swearing. I understand that. You may want to affirm, right? Yeah, you can recite from these notes, Hunter. Okay, someone said yes, they think that it's necessary. Yeah, we'll repost the webinar. Thanks for the hard work. Yeah, I mean, I appreciate it. You know, sometimes some bad apples spoil my, well, they don't really spoil anything, but I kind of laugh at it when people are like criticizing, and then they're not even doing anything. All right, let's just jump in here. I think that it doesn't hurt, okay? When people become police officers, judges, politicians, the president, they swear in. It's just a one sentence, you know? And for you to be able to say, I witnessed this person raise the right hand and affirm, I solemnly pledge to manage, protect, and preserve the trust estate through the prudent exercise of the powers and authorities provided to me by this contract, Declaration of Trust, John Henry Doe Trust. Hey, and then they sign something? I mean, that's as solid as you can get. Okay, but it's a little more than just signing the paperwork. Okay, great. So put today's date on it, make a copy for your records, keep the original in the trust minutes, send the original to me as I will be the secretary to keep the official books and records at whatever the location is. And then, so your second trustee is kind of under training under you. If they don't know enough, you're just going to tell them in the meeting. You're just going to say, okay, great, you swore in, sign this, let's make a copy, put the date on it, you keep it. You're going to keep these trust minutes and records, and I'm going to keep my copy. So now you may want to discuss at the meeting, should we send some notices to the government, the Secretary of State, for the mismanagement of the trust, so on and so forth, UCC1. If you want to talk about all that, you can, or you can just go afterwards and do it on your own. It's just an idea. What are we doing with this trust? Where are we going with this? What are we doing? You can educate to that second trustee if they're not new to this process. You can take the lead and take the role so that you can educate them, and then you can be their second trustee when they set their trust up this way. All right, next order of business. We have a proposal for the trust from the exchanger, whatever the exchanger's name is. It could be a person, company, man or woman, or a person, a trust, an association, a church, or company. We have a proposal from the exchanger which is attached as an addendum to this meeting. Whoever the exchanger's name is has offered to pledge this security agreement so-and-so in this property, whatever, the ring, the bar of gold, the pencil, whatever it is, into the trust. Do we have, and are all members of the board reviewing the bill? Okay, so it's just the two of you. So you're looking at that bill of sale. You got a copy of the security agreement. You read and reviewed that. Good. So just have both people look at it and approve it, okay? Okay, I approve this, okay? Or I motion for the board, the formal way to say it is I motion for the board, to review and approve this. Okay, I approve it, I second it. Okay, we carry it, and it's resolved that this is approved, this exchange. Now we document and sign the documents. Okay, so that's kind of like how it goes. I don't know if you need me to really read. We're almost done. Okay, so just saying out loud, okay, you reviewed it. What do you think? Should we discuss it? Oh, there's nothing to discuss. I agree with it. Okay, well, I motion the board to approve of this exchange. Second trustee says, I second the motion. And then you say, okay. The chairperson, which is you, the first trustee, says, okay, it is carried and resolved. Let the record show that John Henry Doe Trust has approved the security agreement, 05131975 JHDSA, and authorize the issuing of one certificate unit or 25%, certificate interest for the exchanger, whatever the exchanger's name is. Now, can the secretary, Mr. Mark Dennis Awesome, can you please document this in the Schedule A of the trust? Let's make sure that within 30 days, one of the trustees, either you or me, send the certificate to the beneficiary with a cover page notice. All right, cool. And then you can set that aside with that notice to beneficiaries that I was talking about. Can we agree that the notice I've drafted up? Okay, and then boom, you both agree on, you review that notice. You review the notice, you say this is all good, okay, and then it's resolved. We agree with that. We agreed that we're going to send that to the beneficiary, and it's all good. You can even put that into the envelope and write out the envelope ready to mail it out, but there's no need to mail that out right away. You can mail it out, within 30, 60 days, something like that, after the meeting, okay, to send the beneficiaries their certificate and the cover page. So, okay, it is resolved, okay, and then you've got the official identifying stickers that you could put on the trust property to identify the trust property, and within 30 days, any other property that's put into the trust can be tagged as trust property. You could take photographs and then put those photographs, submit them to the board, have both trustees sign it, put them in the books and records, so that you always have a photographic forensic evidence of the trust property, what it looks like, a picture of it. Very powerful stuff in case the property ever gets seized and you need to put a claim on it. The trust shall have a policy to put a sticker on certain tangible property that a trustee deems necessary and take a photograph of the property with a sticker on security purposes. Okay, do you have to do that? No, you don't have to do that. I'm just going above and beyond, throwing anything you guys might need. Next order of business, the trust is in immediate need of a person or persons to serve as managing directors and secretary. The managing director's responsibilities are two. And then this was just a copy. This is just like a bullet point of that. What we discussed in here. Okay, the managing directors will be authorized to conduct day-to-day routine business, to hold trust board meetings, authorized to open one or more bank accounts. Okay, so I just put all that stuff in here, and they say the secretary's responsibilities are to keep meeting minutes, to blah, 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 respect, keep, preserve the privacy of the trust business dealings, records, and the like, to not divulge private information to third parties or governments or courts without express consent of the board, blah, 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 etc., etc. So once you've outlined the responsibilities of the managing director and the secretary, you guys approve the positions, you sign that acceptance as trustee. It's just very simple. It just basically says that you're accepting and pledging to manage, protect, and preserve and exercise the powers of the trust estate. Okay, and you've got one as well for the second trustee to sign, which is a little different. Okay, signed by two witnesses. Okay. And there you go. Now, discussion. I make a motion to have myself, John Henry the Family Doe, be managing director, and to have you be the second trustee, be the secretary. Okay, do we need to discuss this before we vote on it, right? Before I move the board to make a vote, right? Why not have a little discussion about it first, okay? Are we clear about it? Your second trustee might say, well, what are the conditions of this? Let's discuss. Is there liability? Well, we've got hold and harmless agreements here that eliminate your liability. Where do we got that? Yeah, we've got this hold and harmless agreement that limit the liability, be signed by the first trustee. There's also the second trustee is going to have their own version. It will act as a bond, and the trust assets will be secured to incur any liability. You will sign as a trustee to make trust liable, not individually, blah, blah, blah. Can we agree on a unanimous resolution on these hold harmless agreements, or would you like to counteroffer or add anything to it or make any adjustments to the contract? Okay, boom, ready to go. Let's discuss the terms of getting out of this position. If at any point in time you want to resign out of this position, the contract for your acceptance as a trustee says that you can leave, or the declaration of trust says that you can leave at any time with a resolution of the Board of Trustees as soon as another competent individual is appointed to take your place, so that there's not a spot left vacant. So you must give us notice, and the trust will have 90 days to select a second competent individual to replace you the moment you leave. Because again, you always need two trustees, so you always want to do that. You always want to have those terms in there, so your second trustee doesn't resign and bail on you and leave you back with only one trustee, which is a big problem. Okay, let's vote. Okay, I move us to approve this, this, and this. Okay, I second that motion. Let the record show the motion is carried and is hereby resolved that so-and-so will serve as the managing director and so-and-so will serve as the secretary trustee. Sign this, sign this. You make a copy, put it in the trust records. I get my copy. Boom. Each trustee may sign and resubmit to the records of the trust and keep a copy for yourself. Hold harmless agreement. Okay. Next order of business is to approve this abstract of trust and banking resolution. So the same deal, you motion, you resolve. It could be really quick, 30 seconds. You know, I motion, I second, it's carried, boom. Okay? If you're not familiar with that language, just go on YouTube and type in Robert's Rules of Order, or read the book, or get the audio book, Robert's Rules of Order Demonstration. That's a good one. Listen to this chick. She's fun to look at. Listen to this chick talk about it, okay? Robert's Rules of Order Demonstration. I watch a lot of her stuff. I like her. But how to conduct a meeting. See, I can't vouch for anyone else's stuff because I haven't seen it yet, but just use your judgment. You can, in 15 minutes, you can really pick up the idea. If you're a bright guy or bright gal, you can really pick up what the idea is. You don't have to read Robert's Rules of Order, but I'm just referencing it, you know, letting you know where the basic criteria for having an official, formal board meeting comes from. This is the rules. It's like the Black's Law Dictionary of having board meetings, okay? You know, the process of making a motion and second, carrying, resolved, boom, done, right? When you have a meeting, there needs to be a chairperson, right? Someone volunteers, can I be the chairperson of this meeting, right? Or in the Declaration of Trust, it might say that the first trustee is always going to be the chairperson. You might want to put that in your Declaration of Trust. Okay, so there's all these things. There's all these little things to put in your Declaration of Trust as you learn this stuff that you pick up over time, okay? But anyways, the bottom line is you propose something. Do we need to discuss it? I motion for this. You second it. It's carried. Boom, it's resolved. Now we sign the document. That's basically it. So any documents, and you don't need to do that for every document. If you've got the rules say that the managing director can do certain things without having a board of trustees meetings, it says here, the managing director will be authorized to conduct day-to-day routine business without need for board action. Okay? Now, what that is might be more clearly defined in the Declaration of Trust as well. Okay? Declaration of Trust is really, I've seen declarations of trust. Brandon has a good one that's like 30, 40 pages and stuff, so you might want to hook up and get something like that. That's even more as your knowledge and ability to use trusts and understanding of them and getting more complicated over the course of your learning curve. I think he got that from like the Art of Passing the Buck mostly. If you get the Art of Passing the Buck stuff, it's real deep into trust. But this is good enough. This is sufficient enough for this, especially since this trust is not really going to be dealing with a large amount of assets, so you don't need to really overthink things because there's no real worst case scenario. You really just want to make sure that your second trustee doesn't bail on you and that they're trustworthy and loyal and dedicated to what you're doing here with your sovereignty and everything that you're doing. So that's the real purpose of this trust. There's other things that we can refer you to on trust. We are coming out with a trust product as well later on in the year in helping with the management, the bookkeeping, the accounting, the filing of taxes, and the keeping of your ledger and your profit loss statements and writing off expenses and all the different tricks of the trade of managing, running, and establishing a proper LLC, a proper board of directors, a proper 5-year business plan, a proper board proposal for a corporation, an LLC, or a trust. And then on top of that, the people that graduate from that class will be prepared and ready to do the business line of credit approval process that you can get a $100,000 to a $1 million line of credit. You got to have a 5-year business plan. You got to have a few people on your board of directors. You got to have some things in place to legitimize your business and the prospects that your business is going to prosper or that your trust is going to prosper. And it's not that difficult. Using a Dun and Bradstreet number doesn't matter if you have terrible credit. This is based on the Dun and Bradstreet number, which is a corporation's credit number, not your personal Social Security number, and you are not being the personal guarantee on the loan, so they don't even really look at your personal credit as a significant factor. But if you click on this, you can read that we're coming down and offering huge lines of credit. You don't pay us if we don't get you a huge line of credit. It's a simple, cut and dry, to the chase. It's going to work every time, but you got to be officially business-minded. You got to up your game. You got to up your formalization of your business dealings. You're not just doing business in your name with a DBA. You got to be dealing with a corporation, dealing with an LLC, dealing with a trust, having board meetings, having a business plan, having some basic things in place, having some basic accounting and book ledgering skills and meeting minutes and things like that, so that you can run it properly, be legitimate, have competent people running the company, and we can help you get approved for a $100,000 to a $1 million, $100,000 to a $1 million line of credit. No joke. This is the real deal. You don't pay if we don't get you the line of credit, but it's not even that. We're going to help you to check off the criteria of items that you need to have before you even apply for the loan. Before you even apply for the line of credit. It's a credit card. It's not a loan. It gives you a limit to spend, but you're not necessarily in debt unless you start to spend on it. Okay, it's a line of credit. It's a credit card for your company. And generally we can get that in about 90 days. Okay, so a lot of you are saying, what's the payoff? Oh, I got to learn about meetings, and I got to read Robert's Rules of Order, and I got to have a second trustee and all this stuff. There's a lot of mother effing payoff if you guys take this stuff seriously. And we're really looking for some serious students, and the best serious students are going to be business partners of ours at some point later on in the year. So there's a lot of payoff to learning this stuff, and I don't know what you have going on and what situations. We all have different things that are in front of us right now that we want to deal with. That's why we were, compelled to learn this stuff. And everybody's at a different place, but everybody can learn from the proper management and creation of a trust and having board meeting minutes and documenting bills of sale and different things like that. It's just some basic bookkeeping and accountability and documentation that, a meeting of the minds did happen, this and that, whatever. Okay? So anyways, there's some other optional things that we're not going to cover that you can throw into the same meeting. But at the end, you say there be no more business before the board. This meeting is adjourned until such time when either trustee requests or requires a meeting. And that's basically it. So that is the sample script. I'm going to put here begin script. That is just the sample script for someone who's never done something like that, and I hope that that's a valuable product. I hope that that's a valuable thing to, to give to you guys. So, there you go. All right, winding things down. I didn't have the time to really go over all this stuff. We'll continue next week. So I will answer any questions. It's getting pretty late. I'm going to close this up here. So, the first step, and we got a step by step by step, and one thing I do want to also show you is that we've got a detailed instructions step by step by step of the documents and what documents are signed, and then when you're done, after the security agreement is signed, where you go with your UCC and what states are accepting UCC filings, and just very detailed notes, Secretary of State's offices, and how to. There's different versions of the UCC forms. Let me just show you that. You've got the one for New York. This is a sample of how it's filled out. It says type information here. I guess it didn't save the actual information. But we're gonna edit and fix that. We're gonna add it up for. Oh, here we go. No, we didn't. Well, it looks like my materials didn't copy it that well. Well, oh no, this was the other folder. Okay, so this is the Florida one. Okay, it's a little bit different. They have actually privatized their UCC filings, so there's a private company that actually does UCC filings. It's not the Department of State. Very interesting. Then there's this version, which is the national version that most states have adopted. Okay, and then you got the one for New York and the 1AD for New York. So we're gonna, we got in our status course for the people that really support what we're doing here. We got step by step instructions, every step of everything, answering questions every week. We thought we would open it up for like 2 or 3 weeks in a row and try to give everybody on our private membership a sneak peek into what we do, what we're doing behind the scenes here, and giving you guys some first initial steps to start to get the gears rolling in your head in order to reestablish your trust, which is the first step to, from our point of view, to creating sovereignty. So with that ado, I am really worn out. I should be going and drinking some water. I'm starting to get a little bit of a headache from talking so much. So I appreciate you guys for packing the webinar. It really is appreciated for you guys staying out late on a Friday night instead of going out to a restaurant or spending time with your friends or watching Big Bang Theory. So if anyone wants to say anything, comment, or ask questions, I didn't really take any questions, so I would love to unmute people that got their hands raised. Think I'm starting to understand it. Thank you for breaking it down for us. I like the new format. Yeah, I appreciate it. Does each beneficiary need to be an exchanger? No, beneficiaries are not going to be exchangers in this trust. Nope. Easy thought. The exchanger should be either you, the first trustee, or your second trustee, or a third party that's not having any other position of the trust. How can I be a student? You could be a student by just staying on our email list and attending these webinars. We are going to do weekly webinars. We have not done free weekly webinars for all the free members because we haven't had the time to afford to do so. Okay, and we were on a tight budget. And we were losing money every month, and we were trying to get out of the red. So we haven't done free webinars. I'm sorry, but starting from this week, we will be doing free webinars or conference calls every week, even if you've never sent us $1. Okay, that's just something we've always wanted to do. We used to do it, but we fell off because we had to balance our books and our budget and work on projects and dig our heads into the books and really study really hard over the last year. So I apologize for not having that, but we will do that from now on. If you want to contribute to our soon-to-be congregation and support our work in exchange for the 15-week status correction course, I think I kind of covered that. I don't like to oversell and point stuff, but I just want to answer the guy's question. So if you go to our website, understandcontractlaw.com, click on status correction course, this is all the stuff that we cover. It's probably going to go a little bit more than 15 weeks. Initially, I thought it was going to be 12 weeks to cover all this material, but it's a lot of material. You have a lifetime access to go through the material. This is, again, a video that gives you an overview of the basic table of contents, if you will, of the 10 main categories of areas that we're going to go into. But we teach you how to get an international driver's permit, American national passport, et cetera, et cetera, et cetera. And, of course, going through and completing the process that I'm starting to teach you right here, and the following of the UCC, why it's important, answering questions. There's a UCC 3. There's other notifications. There's other things. There's a lot of things. There's training about if you have a court case, how do you use this material to deal with your court case, right? So you can get that, and you can become an apprentice, and you can learn, and the best students from that class who really learn it and do the processes themselves and get it all 100% correct will have an opportunity to get paid to work with our other members to actually help our other members, okay? So if you contribute, it's a tuition. Think of it as paying to go to college so that you can get a job later on. Not also to mention, you're learning it. It's valuable to learn it for yourself, but you can also teach it to other people. You can have other people pay money to you for you to help them with it if you want. We just want you to make sure you graduate the course and learn it, and we'll give you a certificate that you did graduate from it. So we're really seeking people in that realm. But if you want to be a little bit more relaxed, a little bit more chill, and just casually observe the training webinars and stuff too, that's fine too. That's totally welcome. That is totally welcome. Everybody's looking at this at their own pace, okay? So you could get with us about the expenses for getting this paperwork done for you and taking the course, or both, and there is a special on getting both of them for the price of one. Okay, so instead of paying twice to get all this filled out, put it into your 100-page template giving you, all these documents and more. We will give you that for free if you sign up for the status correction course, and that offer ends by the end of February, okay? So but just get with Jay and let him know that you want to do that by calling us during the daytime. I'm sure you guys have our phone number. It's on our website, a few different places. So that's how you can become an apprentice and learn, 15, 16 weeks, however long it takes, every step, everything on recording, 99-year license to either logging into the site or getting a download link that never expires for you to always get the recordings, the editable documents, the step-by-step, et cetera, et cetera. I don't really believe in offset bonds anymore or 1040V vouchers. That's a different topic of conversation, but I don't really believe in that. Yeah, spoken word is powerful. Yeah, if you have your meeting and you speak it out loud and you record it and you save it in your fireproof safe, ain't nobody gonna be able to dispute the existence of your trust, right? So that's the idea, is just getting the signatures on stuff. Some of the stuff is witnessed, some of the stuff is notarized. You're not filing any of your trust documents anywhere. All your trust documents are private. Same thing when you open up a corporation or an LLC. There is an Articles of Organization that's private. Now there's an Articles of Incorporation that's public. It's like a 1 or 2 page declaration that you're incorporating or giving the jurisdiction to do business in a particular state. And you can do that if you wish to do that in the statutory world. You can also get around that. You can do that in the common law, and you do not need to incorporate a business. You can operate through a unincorporated business. That's something that we also set up for people. You can go to our product section of our website. You can call us. You can set up a coaching call. We can talk to you more about that if you're interested. But in a typical LLC corporation, many of you might be familiar with, you file an Articles of Incorporation, but the Articles of Organization is the private documents, right? That's the much more details about the purpose of the trust, the roles, it's the private contract. You don't file that anywhere, okay? That's just on your private books and records. So that's what the Declaration of Trust is, and these can go, like I said, you go to advanced stuff like the Art of Passing the Buck and elsewhere, and you can get, I think the MIC course. They will just talk about, like, the focal point of it is the running and management of the trust, and particularly a very comprehensive declaration of trust and trust indenture. So the trust's information is all your private books and records. It's to be kept in safekeeping in case you ever need it to pull it out in order to prove it, like, say, to a judge or to the IRS or to someone. Why you've been filing all these 1041s? You haven't paid income taxes and filing 1040s and so forth. Well, show them the existence of the trust. Doesn't mean you're going to just go automatically and photocopy everything and give them all that private confidential information, but you can allow them to inspect the documents as long as you are I would hold on to the binder and just flip through it and show them and point to the signatures and the dates and the witnesses. And I would say, you're going to say I'm not operating a trust and it's not appropriate for me to file 1041? Okay, you willing to rebut all this paperwork that I got signed here? You willing to rebut this? Come on. So that's why it's important to have this stuff and to do it appropriately, because if you're going to fill out different tax forms every year, you want to be able to show that IRS agent in his face, hey, listen, this is an express trust. I'm filing taxes as an express trust, not as an individual. Why don't you look at it, examine it, and you testify and tell me which form of taxes I'm supposed to file? I even got an EIN number for an irrevocable trust. Well, how do you think I'm supposed to file it? And they'll go away and leave you alone. You know what I mean? But extremely important to do everything properly. You got this notice to beneficiaries with the certificates sent to the beneficiaries. You got the certified mail. You got them, they signed the green card with their name on it, comma, as beneficiary of so-and-so trust. And this is one that bleeds over to 2 pages. The text is a little bit more spaced out and larger. So you got multiple different versions based on, sometimes I like fitting the document to, 1 page like this one, so that is less paperwork, and then sometimes I space it out a little bit and it bleeds over into 2 pages. Registry of Trust Certificates, boom, 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 boom. Now, I like this one, this Abstract of Trust version 2. I really like this one because we formatted this one a little cool. Declaration of Trustee, boom, 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 and then it's got nice split down the middle, fitting to 2 pages, nice and pretty, notarized signatures of both trustees declaring that all these 12 points are true. So they're affirming and swearing under penalty of perjury all these 12 points of the trust. So this is like something you would show to open up a bank account. The abstract and certification of trustee. You would fill out all this information, bring this to open a bank account. That's the main document you need. And we show you how to do that in the course. And if you have issues and trouble, we walk you through Q&A, trial and error. We walk you through all that. These are the stickers that you would put on a trust property and take a photograph of the property if it's valuable to you. Property of someone's, Mark John Smith Trust, copyright, security agreement number, EIN number, UCC filing number, even you could put on there. Okay. Bank account resolution. Okay. That one's got 2 witnesses on it. See, the unassigned trustees of the above named trust resolved that Mark John Smith, being the managing director of the trust, was or is herein fully authorized by the board of trustees to select and make application to any bank or financial institution for the purpose of establishing one-word checking accounts to serve in the name of the trust, blah, 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 right? So this as well. So that abstract of trust and the banking resolution is all you need to open up a bank account. But not all bank accounts. Most banks don't open up trust accounts. Okay, we show you in our course step by step every intricate detail. That's why I went over those step by step filing instructions. We show you every detail recorded on video with me narrating and reading through every detail, and also a partner of mine is going to be on some of the videos as well that we're still putting together. But step by step by step, we show you what exact bank chains to go to that have the most success, and we give you a sample script of how it's going to go down. They might talk to their manager. They might say, well, we don't know if we can do this. There's ways to get around it. There's tested, proven, and tried stuff. And if you have any feedback that you want to contribute, please tell us. Please tell us. This is how we put this information together, is because there are people out there doing some trial and error and giving us the information and sharing with us, as well as us ourselves, me, myself, going through with some trial and error. So we show you how to do that. And again, I would close down the bank account of Mark John Smith that was opened with just the social, and I would reopen a bank account if you want a bank account that's not in a separate company or whatever, right? If close down your Mark John Smith account and reopen it as Mark John Smith Trust with the EIN number, with this banking resolution and this abstract of trust. Where did it go? I lost it. Well, you guys know what I'm talking about. Well, where is it? The abstract of trust. This one, okay? These all have to be filled in and signed and so forth. It's obviously not filled in yet. What else we got? The security agreement. Okay, this is the infamous security agreement example. Yada, 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 yada. Pretty standard stuff here. I don't really like talking about the security agreement. It's out there. People know about it. There's, UCC secured party gurus out there. I mean, it's standard stuff. The one we got is good, but you've seen that. You've heard about that before. There's other stuff. I don't have the time to really go into all this stuff. And this folder here that you're seeing with these 21, 22, 23 documents, actually 24, 25, 26, 27, 28, 29, 30. There's 30 documents in this folder, right? 32 items. Well, those are those folders. But this is not the complete, everything that you can do. This is a great initial setup. And it's a complete process to do this from setup to give you protections, but you got to go through that sample step-by-step Word document, or get some coaching, or get on our week-to-week webinars in our status correction course, and we'll go over everything in much detail. It's not enough for one webinar, it's not enough for 2 webinars, it's not enough for 3 webinars, but it is a lot to take in, okay? But if you want the secured party process too, you can also just get to our website and fill this out and email to us after you work out some exchange arrangements that are fair, okay? So I'm just going to read the rest of these questions here. I'm kind of worn out about 3 hours later. Really appreciate what you're doing. You have me extremely motivated to learn. Well, thank you, Edwin, who has left the room. All right, most of you guys are still on the webinar. I mean, this is just awesome. Sign me up, brother. This was great information. I like the easy-to-follow script. Well, you're welcome. Thanks, Monique. Great, awesome, thanks. This is great info. Thanks for putting it all together. Who gets the beneficiary interest then? Anyone you select as beneficiaries, your children. But you don't... Did I read that? Oh, my God, I might have skipped something here. Notice the beneficiaries. There's one key point that I wanted to... one key point I wanted to really make. The notice to beneficiaries. Yeah, I think I skipped that. I skipped one of the key points. You may waive, so in the notice to beneficiaries, and this is on the website, right? But it says, you may waive your beneficial position in the trust at any time by providing written notice to either of the 2 trustees listed above. The trustee cannot make distributions to you until you return a signed copy of the letter at the bottom. This does not mean that you are or will be entitled to a distribution in the near future, as that is determined by the Board of Trustees, the Declaration of Trust, and the available wealth or assets in the trust at any time. Really important. So your beneficiaries aren't going to have great access to wealth per se. You can have whatever clause of distribution you want in your Declaration of Trust. You can say that the beneficiaries will only be distributed whatever assets, wealth, or money in the trust whenever the board unanimously votes on doing so. So it could be delayed for years or your life. Okay? It could be delayed a long time. Or if there's money in the trust, you can make distributions of 1% every, 5 years. Okay? It's whatever you determine, whatever is in the Declaration of Trust. And usually you write your Declaration of Trust to be pretty broad, to give you the control, or the Board of Trustees the control to determine when and how, if ever, beneficiaries get financial distributions. Okay? So technically the beneficiaries have the beneficial interest and are the owners. But again, Rockefeller said control everything, own nothing. Or own nothing, control everything. And the trustee can get trustee income and things that are paid for from the trust in order to compensate him fairly for being a trustee, and can have the cell phone bill, lease, any other accounts, vehicles in the name of the trust, and have the trust bank account pay those bills. So it's a way to do business and have stuff that you have the use of the property. Usufruct is the you getting the use of property of another person or entity or individual. So you can use as trustee the trust property. The beneficiaries can get use out of some of the trust property, but it's at the Board of Trustees' discretion. So really, I'd rather be in the trustee position than the beneficiary. I don't know about you guys. So I hope you guys understand that and understand the roles. We will try to break it down for you as much as we can in future webinars. It's past midnight here on the East Coast. I love and appreciate the fact that we had a ton of positive feedback with people registering and getting on this webinar. So we look to do this each and every week, but those of you on the status correction will get the step-by-step status stuff. So try to make that decision if you can. Give an equal exchange and contribute for the status course. It would be great. If not, and you really don't have the money, there's other ways we can still teach you material. It just won't be the exact material that goes over this entire process. So, anyways, without further ado, I didn't unmute anybody. Are we going to have live classrooms where we can all sit down and learn? I don't know. Do you have any students? Yeah, we're going to deal with local students later on in the year. What about the video using the trust interest aside? This is not a Yolanda, this is the process that you want to have initially in order to, if you're going to want to discharge debt, you need this process set up first. There's other stuff like Forms 56, appointing Secretary of Treasury as fiduciary, and then offering them a partnership to offering them a bond to discharge debt. But we don't have time to go into that now. But you need all this stuff set up first. That's above and beyond taking control of the legal name. Okay, discharging debt is an advanced process. You need to have this foundation down first, and then you can have additional meetings to do additional investments and to set up additional accounts for those purposes. Okay, and there's much easier ways to fight debt collectors than trying to set up accounts to discharge debt with the Treasury, because it's very fluid and changing, and they don't want you doing it. And if you do one thing wrong, you'll get a knock on the door or worse. So we really want you to understand what you're doing if you're going to go down that path, and ultimately that's your choice. But there's other ways to deal with debt collectors. You can contact us and find out what we recommend. But there's more mainstream, simpler ways to get out of debt that don't involve any set-offs and things like that. Is it advisable to become an affiliate marketer for every entity you promote? I don't know what that means. Can Express Trust for not own a for-profit entity? Yes, absolutely. Absolutely. You can have a trust that owns an LLC, a corporation. You can do whatever you want. You can structure it any creative way that you wish. Audio dropped when you were talking about not being able to discharge your A4V car loans. If you got foreclosure, there's a lot of mainstream processes. Just call us and ask us, and we'll look at your documents and what process you're in. Foreclosure is kind of easy if you know what to do. Okay? Don't think that you can just discharge your mortgage. They're not going to let you get away with that. It's going to be, I've seen it happen and get reversed. It could be a nightmare. You don't want to go down that path, in my opinion, unless you're extremely advanced. If if you're holding that off for 2 or 3 years or 4 years, and you're really, if you have some special power to really grasp this stuff at a rate like 10 times faster than the average Joe, then go forth and try to figure that out. Go ahead, make that decision. But I hope that you don't need to stop the foreclosure in the next couple of months and you're pressuring to figure out how to discharge it, because that's a recipe for disaster. Because I wouldn't play around with any funky instruments like set-offs and discharges unless you really are advanced. And you don't need to risk that. You don't need to, like I said, some of the gurus recently got charged and convicted of making and using fictitious instruments. Some of that stuff. So be careful, okay? Why would you apply for an IRS EIN number for a common law entity? You don't have to. No, you don't have to. You can get a bank account without an EIN number. That is totally possible. It's difficult. They're going to give you a hard time. You may get turned away a few times, but we're putting a tool together and some documents together to give people a little bit more tools to make it a little bit more possible. But a lot of people without the experience and the knowledge of the law are going to get turned away and pressured into just, the bank's going to refuse you to open a bank account. Okay, so, and this kind of trust usually isn't going to have much or any tax liability anyway. So the only tax obligations if you get an EIN number would be to file a 1041 at the end of the year. To get TurboTax from a Staples office store or buy it online for like, $75, $100 every year. Just go through the fields, answer the questions, and your tax liability would most likely be zero because you're not going to have a lot of money funneling through this that is going to be paid to beneficiaries. So it's not likely that you're going to have income. So since it's the reason why we recommend an EIN number usually is because since it's easy to get a bank account and you're not going to be turned away 5, 6, 7, 10 times and have to recite the law and threaten to sue them for violating the law for not opening your bank account. It's just easier to tell people to get an EIN number, especially if most of the scenarios you're going to not have any income anyway. So you could set your trust up foreign and do a 98 EIN number. You could do that if you are aware of that. Take your own precautions and risks and really dig in and learn what responsibilities you have and if that truly is appropriate based on how many limited contacts or how many involved contacts in the United States do you have. So I just don't want the mistake of people getting a 98 EIN number and then getting in trouble with the IRS because you're getting an EIN number that says that you're foreign and then you're doing business within the United States and then you're claiming you're exempt from doing any reporting requirements from the IRS, but then you're actually not because your conduct is as if you were a 47 series EIN number, but you filed a 98 EIN number. So you could be in trouble for fraud or tax evasion or things like that if you don't know how to operate with the 98 EIN. And if you don't have the proper status as a foreigner, if you do have your U.S. citizenship, if you have your birth certificate, if you have your birth certificate, social security number, and all that stuff, it's going to be very difficult for you to make the argument that you are foreign unless you expatriated or done something else. So it's a sticky situation. I know everybody's talking about getting the 98, but hey, it's like everybody was talking about, OID, and now they're all in jail, right? The 1099 OID filings. People want and people talk about and people post on forums and the stuff that goes viral online fast that everybody wants to talk about is the stuff that is, if it were to work, would be the most awesomest thing in the world, but our approach is to be a little more realistic and a little more on the safe side. So I'm sure you guys can appreciate that. But you could do whatever you want. In the class, we discuss we discuss all the different forms of EIN numbers for every kind of legal entity, including a ministry, a trust, a private foundation. We discuss every kind so that you can make the determination how you want to structure your trust or other trusts or other entities so that you can have, that knowledge. Do they have to know about being beneficiary of trust? That's a really good question, Eric. Beneficiary of a trust doesn't have to know that they're the beneficiary. Okay, you can have in your trust indenture that the beneficiary doesn't know. It's called a blind beneficiary. And you can have in that declaration of trust indenture, you can have that, at the time of someone's death or at the time when 10 or 25 years pass, whatever assets are in the trust, you're going to distribute 10% or 100% or whatever percent to whatever beneficiary or beneficiaries. Okay, so you can say at your death, you give everything off to your beneficiaries and the trust collapses and that's it. And they don't have to know. They do not have to know. So you can set that up. You can put that clause in there. That's why, a lot of these documents that we give when you're in our course are editable documents. but it is beneficial for you to kind of like retype some of the stuff out on your own. But I don't want to make people retype this whole thing, but I hope that you go through and eventually read it, and all the personalization that you can do, you can add in in the appropriate place. The reason why in this type of a trust we give the notice to the beneficiaries and actually give them that certificate is so that you can create the documentation. Like I said, if the IRS or the government or a judge, wherever, were to say, well, let me see proof that you are a trustee of this trust. This is a government-owned, this is a U.S. citizen trust, right? If they were to ever go that angle with you, you can prove to them all the elements of a trust exist. And you've got that green card, you've got the certified mail delivery of this notice with the abstract of trust, 3 pages, and the certificate unit. Where'd it go? Oh, where's that certificate unit? This one, here you go. Right? You've got proof that you delivered this, that this is signed by both parties. You've got a copy. You've got your registry of that in here by the secretary, right? So, and you sent it to them. So that's why in this one I am very keen on sending it and letting them know for sure, and keeping your copies of what was sent. Do you want to even have a third-party witness, another really close, trusted friend, be a third-party witness that signs an affidavit of service and an affidavit of non-response that they didn't respond, refute, or return the trust certificates? That's another option. I think that's a little bit overkill. We've never really seen people, requiring to show that much diligence and proof. You could send it personally yourself and just keep the certified mail and have the photocopies. But, if you want the 2 trustees, go to the post office and mail it together, seal the envelope so that you have your second witness who is also your second trustee that can affirm to the fact that you did deliver the trust certificate units to the beneficiaries. Then that's good. And again, the reason why because you're probably going to send this to your children or something, so or really close friends or whatever, but or charity or something like that, your church, whatever. I would not hand it to them. I would definitely do it through the mail so you can have that documentation that it was mailed, delivered, signed for, certified mail, all that stuff. Okay, so I hope that answers your question about, do they have to know about being a beneficiary? Not in a typical trust, but in this one, I want all the documentation that I need to really restructure this trust and have all the proof that I'm not the beneficiary, that I'm the trustee. People in the status correction course will have access to all the forms and templates. Belinda. This free webinar just really benefited not only me, but you guys, because I went around you guys only taking what was free because I didn't think the money asked for was nowhere near worth it. But I have to say, I will be paying or donating. Wow, okay. Well, there you go. Appreciate it. We don't, I mean, it's likely that might happen, but we really want to be giving people a taste of understand contract law behind the scenes. It is hard for people to, drop a good chunk of money, hundreds of dollars or, or more, if they don't really know the level of attention to detail and the level of 7-day-a-week dedication to improving the documents, making it easy for people, giving clear instructions, and so on and so forth. So yeah, but we also want to create a community where a lot of people ask questions, and we do give a great portion of this material out there for free. We do need to support our soon-to-be ministry and pay its bills and stay out of the red, and fund new projects and things as well. So we appreciate the contributions. But if you guys have an emergency issue that's life or death, we do help people pro bono if you have an emergency situation that is life or death, like we do. We do help depending on our time. What projects we're working on and stuff. Our goal is to be able to help people for free in criminal situations and things like that. As a lot more, but you gotta pay for the roof over the organization's head, first and foremost. Otherwise, we can't do that stuff. So, When you open a bank account for the trust, does it have to be business or personal? It's a trust. It's not a business, and it's not personal. If you were to break it down, it would go under the category of a business, but you have to be, it's a they're going to say, is it personal or business account? You're going to say, well, it's a trust account. Okay, so it's kind of, it tips more to the category of being a business account. So you would talk to the business account banker and so forth, but it's not a corporation, it's a trust. Okay, and not all banks will open that up. Okay, but this trust will not accumulate assets. It may, you can choose to do that, but we recommend not to use this one. This is more of a business trust discussion. Yeah, you could set up a separate business trust as well. It's very similar to this one. Again, once you learn this one, I know it's a lot, but once you go through this once and you learn this, it was a lot for me to learn this over the last, year or two, on and off, learning different things about this. But you really pick it up, and once you learn this once, it's the same thing. You make slightly different edits to the declaration of trust based on what kind of trust it is, and you know what bank accounts are going to open up an account for you. You know how to go on the IRS website and get an EIN number, whether it's a 47 or a 98 or whatever you want, whatever category it's classified as. You make that legal determination yourself or with competent legal advice, counsel advice. But we have a step-by-step of actually going to irs.gov and then walking through and getting an EIN number. So that's another product that, or another, walking people through who have not done that. And then there's a step-by-step, like a cheat sheet on how to get the EIN for this kind of a trust or a different kind of a trust. So that's all included in there. Man, great job, Tyler. Thank you, Charles. Is your screen frozen? GoToWebinar has screen freezes sometimes. I apologize. Trust law is older than corporate law. Yes. Yes. If I have done this process, UCC1 and trust, and the other you bought, is it still possible to continue with what I have done, or do you guys start over with you guys? I don't know if I understand the question. That is process. Can you create a trust based on family member's name and property that is no longer with us? Like, can you create like the Smith family trust? Yeah, you can do something like that. A lot of people do things like that. Property is no longer with us. Well, if you never have title to property, you can't put that property in the trust. So you can't really do that. If you get an EIN, isn't that contracting with the U.S.? Yeah, it is. I think I answered that question a little bit just in the last 10 minutes. It just makes it easier for you to get a bank account, and it enables you to operate in the U.S. If you get a 98 EIN, there are certain restrictions on your activity in the U.S. So you have to be really careful about, you have to be, a little bit more careful. And there's different reporting requirements that a lot of the people that are pushing the 98 EIN or, well, I guess if you get no EIN, that's another scenario. I mean, we discussed these things. We discussed, all the scenarios that you can do and the levels of diligence that you need to do and the levels of responsibility that you need to have at the different levels that you're going to be going at. So just be aware that the 98 EIN, there's a little bit more responsibility, and there are some things that could backfire if you don't take care of them. So we go over that in the course. What countries do you set up our international driver's license and national status? We'll cover that on the status correction course. It's not a country, it's an international agency that issues it. Department of State issues the passport, the national passport. W8BEN is a form we want you to understand before you fill it out. We go over and read the form and help you to understand it before, or we help you to understand it or overstand it. We actually read the instructions with you. 98 EIN is just for limited express trust. We seem to drift into business trust versus single one purpose. What about not-for-profits? 50 states are foreign to the Fed, U.S., the territory. I heard in the earlier audios 98 EIN foreign trust was good for this trust. Oh, that's a very good point, Andrew, at 12:14, 10 minutes ago. I really appreciate that, Andrew. A blind trust where the beneficiary is a blind beneficiary,
is what most people are as quote persons. I would agree 100%. I've never. I would agree. That makes perfect sense. So what you've been doing your whole life, or your family that are not into this stuff, you're walking around with your name, John Henry Doe, all caps. Now we know that that's not you. That's that's a vessel, but that is the beneficiary. It's a blind beneficiary. They've never given you a certificate. They've never given you a notice that you're the beneficiary. I would say that that's mostly true. Again, it's a constructive trust, so they don't necessarily have to, but it's kind of what it is. It's a constructive trust. You could say, it's fraudulent because there hasn't been a meeting of the minds, but it's constructive because, let me give you one other example. You go into a restaurant, you sit down, you order food on the menu, and you walk out without paying for the food. Now, you never had a meeting of the minds. You never signed an express contract like the Declaration of Trust with the restaurant owner saying that you were going to pay for the food at the end of the meal. But it's a constructive contract that you will pay the bill at the end of the meal. And it's not fraud because you got consideration. You got the food. You don't just go into a restaurant, eat food, and expect that it's free unless they specifically say you're exempt from paying. Oh, this is just free chips and salsa. Yeah, you can sit in here and drink our water. Oh, yeah, we're having a happy hour, and chips and salsa are free. You can just hang out in here. There's no charge. So unless they expressly tell you otherwise, if you're given consideration, there's a duty and obligation, or there's a trust at play, okay? And it doesn't need to be a meeting of the minds to the extent of having a signed contract between two parties, with witnesses and, something like this here, okay? So that is a very cool point, that we are blind beneficiaries of the straw man trust, and we don't even know it. We can't see the screen. Oh, okay. Well, no one else says that they can't see the screen. I apologize. We're going to be, when some extra funds come in, we have it in our budget to upgrade to a better webinar service. Honestly, right now I'm using the free. The reason why it got cut off at 100 is because we're using the free GoToWebinar, and the free version, like basically you create a free trial for 30 days, and then you don't pay for it, and then you open up another free trial with a different email address, and you keep doing that every 30 days, and you never have to pay for it. Otherwise, it's $99 a month. Okay, so our organization doesn't make enough money that has that budget right now. We're working on getting to pay for a webinar program. Okay, there's other ways that the money is more better spent in our organization. Whereas if we can just get a free webinar, but now since we're having 80 people that couldn't get on the webinar, we're going to have to pay for it. I'm going to have to convince the the board to vote on that. So that the quality, if it keeps cutting out, if the audio keeps cutting out, it won't happen. We're going to upgrade to a better webinar program. So just hang tight for next time. And any material that you miss, we're going to go over. We're going to go over. It's going to be detailed in the products. It's going to be detailed in the status course. So, just bear with us. What about using notary publics? How do you use the services in this process? Are they necessary? Notary publics are just to witness signatures. If you ever want that signature, to be on its face, completely acknowledged and respected by the United States, like a judge that, like in a courtroom, if you want it to be, in other words, if it might be contested or if it's a really important document or an affidavit, you may want to put that jurat on the bottom. I'm going to try to see which of these documents has a jurat on the bottom. Most of them do not. The security agreement has a jurat. Okay, see? So you got your signature, the date, and then you've got the state of, you write the state in, the county of the county, and then the notary, it just says subscribe to before me on this blank day of blank 2005, the notary's name, comma, a notary that Mark John Smith personally appeared and known to me to be the man whose name subscribed to the within instrument acknowledged to be the same. They put their seal, they put their commission expires, they put their stamp on there, boom. Okay, so on its face, that is generally accepted as authentic, that this notary witnessed. This notary is commissioned by the Secretary of State to witness signatures and affirm that that is your signature, the person who signs that, right? So, or the man or woman who signs it. It could be a person or a man or woman, but they're acknowledging that. And if you get authenticated apostille, then it creates irrefutable documentation, and then you can submit it to a court case if necessary. But you know, in this scenario, you're not submitting. This is private documents. But if you needed to prove the existence of the trust, you can redact the document. You can just send the last page, and you've got that date and signature and the date of notarization. This is one of the main documents that proves the security agreement that the living man or woman has taken control of that trust and has a gigantic lien over the trust. And if you just read, I mean, if you read through this and you go over the future courses, we're going to go over why that's important and what that effect has. But I'm sure you guys have read about the typical UCC redemption process, and you get the idea kind of what, because there's a lot of people talking about it, but I don't think that it's nearly as complete as what we're putting together. And that was been the drive all of last year, leading up to trying to put all this stuff together, complete, so that people don't have half-ass information and half-ass like 2 or 3 documents that aren't complete enough. So, okay, some people left but said they'll, you know, we will remember them. They will get back with us. You guys have been very generous with the info. Yeah, going on 3.5 hours now. Okay, my trust should focus on this trust. Okay, when are you guys going to stop asking questions so we can end this? Should this type of trust be used for receiving income from real estate rental property? No, that's not really what this is used for. But if you go through and create this is the first trust you want to go through and create, in my opinion. It has many purposes. And then you can use similar documents to create secondary trusts with different parties on it. You can't have the same parties for different trusts. If you got the same creator, the same trustee, trustees, same beneficiaries, it's not a different trust. You need to switch it up and make different parties in those different roles. Okay, so you have to pick different people in your life. You know, the relationships and friendships and family that you have in your life that are you know, supportive and loyal and dedicated to you are one of the most valuable assets that you have. And you can't really go and confidently be creating multiple trusts if you don't really trust anybody. You don't really have family or friends that will be there for you or would like to support you in any way. So, you know, that's just basic success in life skills to, you know, maintain and nurture those relationships. So when you do ask people for help, it's not like you're coming back and being like, oh, I need you to help me for something. For me, you know, so I hope that most people on here don't have a problem finding additional parties to be second trustee, beneficiary, whatever. But if you really, you know, if you live in a small family or you live in a small town and you don't know a lot of people, you can ask us. We wouldn't mind being a protector. Like I said, we also might not mind being a second trustee, depending on if you're supporting our ministry, soon to be ministry, or our organization. You know, if you're offering something like a donation of some kind or something else, you know, we'd be happy to provide for you what you need to fill in. Yeah, join me is okay. Can you repeat how we can make donations? Well, you don't need to make a donation just blindly. You can make donation in exchange for some of the products. So we added a lot of new products. You can also call us at the number, here you go, 505-340-3632. And you can see if you have a need that maybe we can offer something. We have products that teach you how to fix your own credit report. We have a lot of stuff. Letters to get debt collectors to go away. We have a lot of things. So we would love to exchange something in exchange for donations. But if you wish, to give a donation, you can, I guess you can do that. You can go to coaching calls and you can just put in a $50 donation or $100 donation, but you know, we'd like for you to get something. So, you know, I mean, and you can donate now, and then you can get back with us in the next couple of months or couple of weeks, and you can use that donation money that you put in there. We will always honor that if you feel like you just want to be generous and not, you know, you're not sure what product you want to get right now, and we'll use that money to pay for the upgrade in the webinar over the next week, and we appreciate it being sent to us up front, and then we promise that we will give you whatever product, whatever service, whatever help, coaching, mentorship, whatever you need, and we will apply the funds on account to exchanging that at the time that you you know, that you call that in. Okay, if that sounds fair. And the status correction course is a significant donation. It's a $1,500 donation, but we're offering that we will do your SPC filings. We will actually input into the we will get you to input your stuff into these fields, and we will actually send you a template completely filled out with instructions from the, you know, during the class as well. So that you're getting for free with a $1,500 donation for the status correction course as well. So, you know, so if you, it is a significant donation because there's a lot of time and effort, and there's multiple, you know, trainers, facilitators, and costs and expenses involved. So, you know, but that's the price. You did not miss this part. You went through it. Okay, free webinar just really better. Okay, boom, 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 boom. I don't want to keep. Michael, thank you for all the starter info. I look forward to receiving the information tomorrow. I'm going to turn in. Have a good night. Yeah, see, a couple people are saying they're going to turn in, so we should probably wrap up some last few. It's okay to make suggested donations to exchange for expertise. I do it in my ministry. Okay, yeah, exactly. So yeah, so Yolanda already has a ministry, so that's great. And there's a lot of people that just don't know how to set that up. So if people want to set that up, we set that up. I think we do it for like $500. I got to check. It's a new product, so we threw a lot of new products on here last night. So, but if anybody wants to set one of those up, I believe it's around $500 to help you set up your own ministry and give you the detailed instruction. You guys know how detailed I am in making sure you have all the tools. You know, so you can go set up a bank account, and I give you a script, you know, of anything. And if there's something that falls short in one of the products, I will just like, this is my policy. If there's a product that, like, the products are always a work in progress, right? So if there's some hurdle that you hit in doing something, let me know, and I might even work on it that day if I have the time, because I don't want the next person to have that same hurdle in getting that step done. Okay, so you know, I'm sure you guys can appreciate that. So we're always continuing to make it a smooth process where you guys, you know, you don't need you don't buy a product and then everybody calls us to get help because the product is incomplete. That's not, you know, that's not giving us the free time to work on other stuff that we want to work on, right? So we always want to make the products as complete, and as time goes on, add in some things. So one quick rundown. What is that? Look for the starter info. Go to bed. Yeah, have a good night. Looking forward to the next seminar. How that benefit me in a court case, and also All right, guys, I'm going to end it. I'm going to stop the recording. Have a great night. See you next week.